Good morning. It's time for coffee and cursey words. I just realized I forgot to change over the chat, so I'll do that. Replay crew, love you. There will be timestamps down below after the stream. Thank you so much for being here. Don't forget to go ahead and like and subscribe and do the YouTube things. 'Tis the season. We are at 189,000 subs on our journey to 200K. So excited to be here with y'all. So much to talk about. We're not even doing a quick bits today. It's just these two different motions because, of course, James Yeeted Spears' lawyers filed 800 pages. We're not going over all 800. And then there are so many different motions going on in the Chalene Johnson defamation suit. So we should just get into it. We will do questions at the end, no matter how long this takes. I have coffee, I have cursey words, I have water, I have my facts shirt. I am ready to dive into all of it. It is Christmas week. I hope all of you are feeling well, and let's just get into it. Let's just get into it. I'm going to roll the intro and we're going to go because we have lots to talk about. As I say, as I'm looking for my intro to roll. I mean, professionals here, people. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Before we get all the way into it, though, I do have to say, tomorrow we have a new episode of The Emily Show coming out. I hope that you all will be waiting for it to show it some love. It has some exclusive moments, and I'm very excited to share it with you because it's a Girardi breakdown of the contempt hearing with some exclusive voicemails of Tom Girardi that relate to, without spilling all the tea, that relate to some of the things said in the contempt hearing, which is absolutely wild. It's good to see all of you coming in from literally all over. I see you guys from all over the world. Thank you so much for being here. We're going to talk about Britney first, and then we're going to talk about the Chalene lawsuit. The Chalene lawsuit is there's just more documents to go over, and I've been wanting to talk about it for a while, and it's a new topic for us, so it always takes a little bit longer when we dive into a new suit that will be added to our continuing roster of things that we cover, because I don't see this one going away anytime soon. So for any lifers that are watching, thank you for coming over and saying hello. And we should just pull up the Britney documents. Look, James Spears is trying it. I should swoop. I'll do that. Let's swoop first. Let me get down to our documents. They are loaded in, but I need to make sure they are like locked. My file of Britney Spears legal documents is so long. Now it takes to get to the very bottom, because I do them by date. So to get to the very bottom, it takes me like 4 scrolls down to get to it. So hello in Norway. Hello, Netherlands. Hello, Germany. It's so good to see everybody. That's the one thing I do love about doing coffee and cursey words in the morning, is that it is much easier for the international crew to get to hang out with us in the morning. So let's swoop. I should have a sip of my coffee. It's going to be a busy morning. I changed my mic. You guys, it's like a whole new me. Actually, my camera is we're just going to, professionals. It moves. Fred was climbing on the back of my computer the other day and bumped the camera, and then as I turned it off and on. But I moved the mic, so I have more space. I think I can gesture with my hand, like dun, 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 dun. I can gesture with my hands more. I like it. You'll have to let me know what you think, if it's distracting or not distracting. I like it. I like it. Thank you for making this challenging year a bit better with your video and live streams. Thank you, Mr. Unicorn. Being part of the Law Nerd community has brought me so much joy. Wishing you and your loved ones happy holidays. Thank you. That is so tremendously kind. I will be doing a fun stream on Thursday, just for community, for questions, to hang out, to say hello, and maybe talk about some fun legal stuff. Hi from a poll in Sweden. Hello. Um, because it is I definitely need to make sure that I spend the time not working because I need the downtime and I will definitely be taking some downtime, but also a fun stream for the community so we can all hang out, have a drink and just chat about everything. Good to see you, Kristen McCall. All right, let us. Rachel Mills asked, are we on verdict watch? We are on verdict watch for 3 cases. I will be covering verdicts unless something absolutely wild happens. I plan on talking about them on Thursday if they're in. I will share on social media what happens. If you like the way I break things down on Instagram, on Twitter, go ahead and follow me there at the Emily D. Baker, and I will break them down there. But I am waiting for verdicts from the Elizabeth Holmes case, which might take a little bit. I mean, it was 3 months of testimony, and it's a lot of jury instructions, and it's a lot to parse through. For Kim Potter, I would be surprised if it doesn't come in this evening, but one never knows. It depends on what goes on today. Excuse me. And for the Maxwell case, for Ghislaine, did I get it right? Ghislaine, Jolene, for her case, Shane Dawson, for her case. And that's a joke. If you guys used to watch the E&B car rants, where when he could not get a name right, he would say, is that Shane Dawson? Because he still doesn't know who Shane Dawson is. And it always got a giggle from the law nerds. So, Doll, thank you very much. I'm very excited. The solstice, like the peak of the solstice, is soon-ish in this area. So I'm excited, and happy solstice to everyone else. I feel like with Thanksgiving, our family is going to start celebrating like the harvest and the solstice, and maybe not as much Thanksgiving. Joe Jersey said, can you all send prayers to my mom in ICU since last Monday? At least 3 heart attacks, but CPR saved her. She's a little Irish lady fighting for her life. Well, we know that if she is Irish, she is absolutely a fighter, Joe. I am sorry that you are going through that, and I will absolutely, and I'm sure the law nerds will send you all of their blessings as well. So from blessings to maybe not blessings, let's talk about James Spears. James Yeeted Spears. Yes, we have changed his middle name. We are no longer calling him Dad Spears. All of you quite rightfully pointed out, you're like, does he deserve the title? And I'm like, biological titles and like emotional titles are different. But I think that James Yeeted Spears or Yeeted Spears works well. The channel does like to nickname people. I feel like calling him Bad Spears is maybe a little heavy-handed because we really do try to not name call, but Yeeted is just like a statement of fact. So we'll just go with the statement of fact. Yeeted Spears through his new attorneys. Remember, Viv and crew are no longer his counsel. He has new counsel, and they are doing the most. Like, they're doing the most. They have filed another motion regarding attorney's fees. Now, to be fair, they have like 3 or 4 pending motions, and the 3 or 4 pending motions total over $1.3 million in legal fees for months of work. I would have to go back and look at how many months, but from the multiple law firms he worked with as conservator. As conservator in the past, the court has ruled that his legal fees are paid for by the estate, and the court has approved those legal fees. That is all still part of the 12th accounting. Those motions are set for January. There are still lots of objections to them. It's like, I object to Media Matters. If you recall, the over $500,000 that Viv and crew spent on Media Matters. And by the way, I do not call Viv colloquially Viv because of anything other than reading that transcript in court where she was like, Your Honor, he's a stranger. Like, he doesn't even go here. We don't know him. And I was like, the Viv it just is. It's not meant with undue disrespect. So it's meant with due all due respect. So with that, his new attorneys have filed a motion for legal fees. Now, on the next court date, we have to deal with the 12th accounting, the attorney's fees from Viv and Co., the attorney fee motion from Lynn Spears. Do you remember how pissed I was about that? Ooh, bitch. This one's going to be like that, I think. I haven't read it yet. This is a first look for all of us. Unless you've watched other content, I'm sure that others have covered these already because they came out a few days ago. But this is a first look for me. So with that, we've got lots for Rosengart to be doing. And this is a motion for legal fees that comes after James Spears has been yeeted. So I put it in the same category as Lynn Spears' motion because he is no longer the conservator of the estate. In my mind, the caveat is that if this is winding up work that he legitimately did as conservator, and it is legitimate work that he needed to finish, then perhaps there are some things that could legally be proper. It doesn't mean they won't annoy me, but they could legally be proper. So let us just jump on into this and do a first look while I drink some coffee and try to keep myself calm. We're trying to breathe. Also, can we just do a big old thank you to the mods for being here? It's the holidays. It's holly jolly. Also, with over 2,000 of you watching, if you're not subscribed, I'm going to remind you all stream to do that ad nauseum because, again, vanity numbers sometimes make me happy. Jamie Yeeted seeks the court's confirmation, authorization, and direction for the estate of Britney Jean Spears. Look, the estate is winding up. Britney is no longer in a conservatorship. Spears is no longer the conservator. To make payments on account to Jamie's attorneys participating in proceedings concerning Jamie's ongoing fiduciary duties relating to the winding up of the conservatorship of the person in the estate. He has not been the conservator of the person for a number of years, and the attorneys of Jody Montgomery are handling that. So what are you doing to wind up the conservatorship of the person? You were not involved any longer. Jody Montgomery and her lawyers are involved in that. So I take issue. I don't think that's accurate. I trust the court has a memory better than mine for this because they have been more intimately involved. Prompt payment. Okay. Prompt payment on account of Jamie's attorney's fees is necessary. For who? I'm going to try to take this seriously. I cannot. Prompt payment on the account of Jamie's attorney's fees is necessary to ensure the conservatorship can be wound up quickly and efficiently to allow Britney to take control of her life as she and Jamie desire. Bitch, come on. This reads to me like Alec Baldwin's interview with, I couldn't wait until they finished the investigation. And I'm in this situation. Helena and I, the woman he shot and killed, perhaps accidentally. There's still a investigation. But Britney and I, this is positioning. Britney and I are in the same boat where we want her to take control of her life. And she can't take control of her life until my lawyers are paid. No, Yeeted. That's not how this works. Oh, the fuckery that's already afoot in this motion. Oh, we're twitchy. We might have to go red soon. I'm already. The daddy loves her of it all of this is already getting to me. Jamie stepped up to protect his daughter in 2008 and stepped into the role of co-conservator when Britney was unquestionably incapacitated and victimized by persons seeking to take advantage of her incapacity. Y'all see that New York Times article about about Lou Taylor and about the loan to Jamie Spears prior to the beginning of the conservatorship? Who was taking advantage of who is my question. I have questions. He received a large loan, like $40,000, received a large loan from TriStar, and then TriStar became inextricably linked with this conservatorship. And all Matthew Rosengart has been asking of TriStar is, how much money did you make? And TriStar's like, it's probably in the documents. I mean, get a calculator, add it all up. Oh my God. Oh my God. Oh my God. He found lawyers that can just voice the narcissism into writing on another level for me. It just reeks of manipulation. And that is just me. We're going to try to get to the end of page 1 and then we'll go red. We're going to get to the end of page 1. We're going to get to the end of page 1. But this sentence alone is this sentence alone is DEFCON red warning worthy, I think. And for those of you that are new here, pop a 1 in the chat, and the OG law nerds will explain DEFCON red in the chat. So let us know. We love new law nerds that find us every single live stream, but also we'll explain DEFCON red before we get there. Oh God, there's more. As co-conservator, Jamie dedicated himself to protecting his daughter's health and her estate, as he has done her whole life. Yes, we know you've been in control of her whole life. Thanks for clearing that up. While keeping opportunistic and wholly self-interested parties at bay. That's it. I'm out. Flash warning. I love the DEFCON red intro. When the music stops, the flashing will stop for anyone who is flash sensitive. Look, I love it. I love it, but it does flash a bit. So that's your warning. I got to make sure that we're ready on my end to go to red, because I really do try to time it so I can be red by the time the flashes are done. But I'm out at keeping opportunistic and wholly self-interested parties at bay, because I feel like maybe you opened the door and invited them in, but that's just my speculation. It's early in a stream to get to DEFCON red, but we're at full level what the fuckery. Like, we're at full what the fuckery levels, because seriously, because it's the rewriting history for me. Woo! Okay. We gotta reset before we get back into this, because oh Lord, I need patience today. This is not a drinking stream. I should have saved this for a drinking stream. Yeah. All right. Jamie's 13-year administration as co-conservator of the estate has been certified and approved at every step. Well, also, it wasn't objected to by Sam Ingham. I don't know if that means it was right. It means that somebody didn't object. Throughout the duration of Jamie's tenure as co-conservator, his actions were affirmed by at least his co-conservator, Andrew Wallet, and by Britney's court-appointed counsel, Sam Ingham. That doesn't mean it's right. Also, Andrew Wallet quit. God, wouldn't you love to see a deposition of Andrew Wallet and know why he left and what he knew? B, approved by the court. Okay. No findings have ever been made against Jamie's administration of the estate. The court assessed and approved 11 accountings of Britney's estate, and the court assessed and approved 11 accountings of the estate, and no petitions regarding Jamie's role as co-conservator of the estate have pointed to any cognizable wrongdoing regarding the administration of the estate. Well, they've raised a lot of questions, and those motions have come up. Even Sam Ingham brought some, but okay, go off. I mean, there were more than one motion. How you see things as cognizable give you some opportunity to try to not be completely intellectually dishonest, I suppose. Jamie promptly took steps to end the conservatorship to ensure that he wouldn't be investigated further. I'm sorry, I hallucinated. That's not what that says. To ensure Britney's estate is not depleted by a self-interested entourage of handlers. Counsel? Oh, you're coming for Rosengart now. Adorable. and other persons feigning concern for Britney's welfare after Britney voiced her desire to take control over her life and career. Oh my god. Oh my god. The gaslighting of it all. I look. The gaslighting of it all. A self-interested entourage of handlers, counsel, and other persons. Who are the other persons? Is he trying to refer to Lynn Spears or himself? And also, I don't know who the handlers are. That's fine. But don't rile the Rosengart man. Oof. I hope that this motion fortifies in Britney and counsel and whomever the deep rooted belief that they need to continue on in their investigation into WTF has been happening with this estate. I really hope this is like the final nail of we're never letting this go. We are going to fight this to the ends of the earth forever. I think that's what they're doing here. I think they've solidified the rage for Rosengart. Right. That would rile the lawyers. If I was Rosengart reading this, I'd be having the same reaction, I think, in my office. I think I'd be like, the fuckery of it all. To that end, Jamie petitioned the court to terminate the conservatorship so he wouldn't be investigated, I think. Those are my speculations. Because the timing of the 360 or the 180 was very interesting. I mean, as pointed out by Rosengart's motions, but y'all remember that. There are days that I wish that my coffee I should have put Irish cream in it. Today is one of those days. But no, we have holiday things to do afterwards. I just breathe. Okay. The court granted Jamie's petition to terminate the conservatorship on November 12th and has initiated proceedings to help expedite the winding up of the conservatorship with someone other than you. It is being wound up by another temporary conservator of the estate. It's not being wound up by you. Jamie's ongoing attorney's fees incurred to finalize the conservatorship are compensable from Britney's estate. Oh, tell us how. The fiduciary obligations Jamie owes did not end with his suspension. Oh, we've admitted it. Oh, y'all, credit where credit is due. Credit where credit is due. We've said the word and admitted the thing. We've said suspension. Honesty. Okay. At least that's not being rewritten. Or with the order terminating the conservatorship. To fulfill his ongoing obligations, Jamie and his counsel must, among other tasks, transition administration of Britney's estate to Britney's representatives, which involves 13 years of records relating to the $57+ million estate. But those should have all been with the business manager. Why are you keeping records, Jamie? You shouldn't be keeping records. They should be with the business people. Finalize the 12th account current relating to Jamie's administration of the estate in 2019. That's accurate. He does need to do that. Prepare a final accounting covering the period from July 1st, 2020 to present. I wonder if that's properly the charge of the new temporary conservator of the estate. Continue to engage in discovery relating to his prior administration of the conservatorship initiated by Britney's representatives. That's on you, boo. Attorney's fees to carry out these fiduciary duties are chargeable to the estate he has administered for the past 13 years. Britney should pay me, is what he's arguing. Well, Britney's estate. Payment of those fees on the same terms as all other parties in this matter is vital. It's vital to ensuring Britney's interests in ending the conservatorship are promptly completed. No, it's not vital for Britney's interest. A new conservator of the estate was appointed to wind up the estate, not you. Okay. Jamie's suspension. Ooh, we said it twice. I'm going to drink on this one. Good. Jamie's suspension as conservator of the estate does not excuse him from participating in proceedings to winding up the conservatorship. Well, it doesn't. But does it require his participation such that the estate has to pay him? I'm not sure on that. I'm not. Or negate the requirement that his attorney's fees must be paid from Britney's estate. Yeah, but this is Jamie who we know from reporting from the New York Times and others, has failed to show up to any of the depositions he's been subpoenaed for. So you can't have it both fucking ways. You don't get to say, Britney's estate should pay me. I'm actively participating in winding up their estate, and then ignore multiple depositions for subpoenas. No. Oh my God. Jamie still owes fiduciary duties so that Britney's best interests, every time I read Britney's name in my head, it like translates into James's name. It just translates into Jamie still owes duties so that Jamie's best interests are protected. Like that's how I hear it in my head. Throughout the proceedings, finalizing and terminating her conservatorship. You still need me, Britney. You still need me. Without daddy, this isn't going to get wound up. I feel like it's almost vaguely saying, hey, if my attorney's fees don't get paid, this shit's going to take forever because I'm going to make this shit take forever. But he's not in charge anymore. This feels to me, speculation, feelings, gut feelings, like a power play, like a control-based power play of none of this is getting wrapped up without me. Britney's in control of her home life. There's someone new in charge of her finances. When everyone says you're dead, sometimes you have to lay down and die. No, that is not a threat. It is a Heather Dubrow quote for all of you housewives lovers. We do not make threats against individuals on this channel, even when they make vague veiled threats in their legal documents. But that's just my speculation. Payments of Jamie's attorney's fees from the estate is required regardless of the unsupported ad hominem vitriol lodged at him. Look, here's the thing, though. I will say, credit where credit is due. They did say suspended at least twice so far. We're only on page 2. Lord help us. And the writing is at least clear and concise and somewhat clever, and we appreciate that. How much she's paying for that, I would love to know. Jamie's attorney's fees should be paid on account on the same terms as other parties in this matter, consistent with the law of equities. Oh, we've gone way back to the law of equities, requiring that all parties tasked with administering the estate be treated on equal terms. You're no longer a party tasked with administering the estate, though, bro. Suspended. Public policy also requires that parents don't take advantage of their children. Wait, what? No, that's not what it says. That's not what it says. Public policy also requires that Jamie's attorney's fees be paid by the estate regardless of the baseless allegations asserted against him. To that end, Jamie must be afforded the same opportunity to retain and regularly pay counsel on account from the estate that has been granted to all other attorneys associated with the 13-year conservatorship. No, not all other attorneys. Lynn Spears' attorneys don't seem to be, well, we'll see what the motion says. They're not being paid on account, meaning that they get paid and then it gets approved later. They're not being paid on account, nor should yours be after the suspension. The delusion is real, but you're not similarly situated to the other conservators anymore. Now, to the legally obligated, and I can't wait to see Rosengart's response, but to the legally obligated winding up that he must participate in, it's different than all of it. And there might be some that is legally appropriate. It's not going to be all, though. It's a no for me. They go on to say that Jamie's participation in each of these pending and forthcoming proceedings is necessary to advance the best interest of Britney. It catches in my throat when I try to say it. To achieve this, Jamie has employed Wilkie Farr and Gallagher to represent him and accelerate the proceedings to finalize the conservatorship. How are you accelerating shit when you're not showing up to depositions? Just a question. Also, new conservator of the estate has been appointed. So are you withholding things? I just wonder, are things being withheld? Because there was a lot of tit for tat in earlier motions where it was like, well, if you don't do this, I'm not going to do that. Are things being slowed down so that they can then be accelerated? I'm so curious. Is there a willful I don't know, disregard or decline to participate until the attorney's fees are secured. Cause yikes. Cause yikes. Cause yikes. I keep forgetting I have my new Stream Deck where I can just like, I don't have to use my mouse to do the things. I have buttons to do the things, and it's very exciting to me, but I keep forgetting it's there. Okay. Okay. Yeah, Anna has pointed out the operative fact here: big guns and expensive. Yes, but the writing is good. Look, we're going to say so far we might not agree with the position, but these attorneys are being paid to, well, at some point being paid to take this position. They are being zealous advocates for their client, and so far they've gotten through a whole motion. Well, no, we're only on like page 3. We'll see if they can get through a whole motion without saying Britney's daddy loves her, at which case I will at least be appreciative of that. Jamie's ongoing attorney's fees should be paid on account from the estate at the same 80% of monthly billed fees and 100% of costs, no, subject to periodic court approval. Arrangement afforded to other parties in this matter, you're no longer a party, until all matters relating to the termination of the conservatorship are concluded. That's going to be a big no for me. That's going to be a big no for me. It's a no. It's a no for me. It's a no for me. Statement of facts, as they see it. A conservatorship is established over Britney for her protection, and Jamie steps up to protect his daughter. I feel like it's analogous to Daddy Loves You, but it just isn't quite as creepy as actually seeing Daddy Loves Her in the legal filings. But we know the history. We're skipping. Jamie requests appointment of new conservator of Britney's person following Wallet's resignation. Yes, we know. The court approves Jamie's actions as co-conservator, including by approving 11 countings and making no findings against Jamie. No one objected. The court is not doing anything sua sponte, and no one objected. That doesn't mean it was right. Lack of objection does not equal right, but it's not factually inaccurate. Britney's court-appointed counsel initiates litigation to challenge Jamie's 12th accounting of the estate because things had gone too far. Part of the things that went too far by my memory is the actual just flat out approval of the change of fee agreements with TriStar. That was one of the things that raised objection that we talked about over a year ago on the podcast episodes and here on this channel, was that when Britney said she wasn't performing anymore, TriStar came back and said, well, we normally get a percentage of performance, and if we're not getting a percentage of performance, we need this like $400,000, $500,000 flat rate. And Jamie Spears sent back an email and was like, yeah, cool. Summarizing. But that's one of the things that Sam Ingham started stepping up and objecting to. On September 18th, 2020, Ingham petitioned the court to retain Loeb & Loeb as litigation counsel regarding anticipated objections to the 12th accounting, and then made a motion to yeet James Spears that was then denied by the court, but more details. The court authorizes monthly payment on account of all parties' fees. Parties. How do you define a party? Because I don't think as a suspended former co-conservator, you're a party anymore. I'm not going over the old rulings. We know what they are. We've talked about them quite a lot. And we know that again, that is how they were being paid, 80, 100, and then approved later. The courts approved those. Sometimes it's hard to say. Jamie fiercely defends Britney's interests and takes steps to terminate the conservatorship pursuant to his daughter's pleas. Okay. Jamie consistently performed his duties as co-conservator with the best interests of his daughter in mind, including her desire to end the conservatorship. Most recently, Jamie supported Britney's decision to obtain independent counsel. Good. Yay. And now you deride that counsel in the same motion where you said you supported her decision. Objected to Montgomery's security request to ensure A, enough priority was placed on Britney's security needs, and B, Britney approved the cost of security requests that would be borne by her estate, except that you told Jody Montgomery you would pay them, but that's minutia perhaps. filed a petition for instructions to inform Britney of her options so that she may make informed decisions about her medical care. When was that filed? Oh, Exhibit 32. Good. Petition to terminate the conservatorship, Exhibit 34. We know that that was done. Great. This is why, by the way, every single motion is attached, which is why the other thing is 800 pages. Over the holidays, I'll probably go through that and see if there's anything new that we learn in that. We're not going over all 800 pages today because we have another case that we want to get to too. The court terminates the conservatorship and denies Britney's petition to remove Jamie due to lack of sufficient evidence. I believe that they suspended him and the removal became moot. I think that I'll be interested to see how Rosengart responds to this. After Britney's testimony on July 14th and June 29th, Jamie opposed Britney's efforts to remove him as conservator. Yes, he did, merely as a technicality. Oh, it was merely a technicality because there were a whole lot of motions in there and you threw Lynn Spears right the fuck under the bus and said that it was everybody else's fault. But okay, I guess that's a technicality. Sure. Remove him as conservator merely as a technicality because his duty as fiduciary to defend the previous and outstanding accountings. Jamie, okay. So their positioning, interesting. Their positioning is that the reason they wanted to remove James, the reason that Britney and her attorneys, the reason they wanted to yeet James Spears, that the entire purpose of yeeting him was a technicality because they didn't want him defending the outstanding accounts where his attorneys are entitled to over $1.3 million. Well, are arguing that they're entitled to over $1.3 million. So they're saying that's a technicality because there was more in the motion, but the revision is interesting to see. So they're saying that the reason he's removed, not because of all the other shit they said in their motion, to that. It's because he would defend the accountings. Sure. No, James, that's not the entire reason. That wasn't the reason in Rosengart's motions. But, I've read all of these at this point, so at least I remember. The law nerd's memory is long. We drink and we know things. Let's continue on. Jamie agreed with the court that it would be in Britney's best interest for him to resign. But you never resigned! I can't even get through a sentence right now. I can't even get through a sentence. Jamie, when did that happen? Jamie agreed with the court that it would be in Britney's best interest for him to resign and attested that he planned to work closely with Britney's new attorney to ensure a smooth transition to prioritize Britney's best interest. The caveat to that is so long as my attorney's fees are paid on account at 80% right now, please, thank you. But he never resigned. He was suspended. He refused to resign. He was asked to resign by Rosengart like at least 5 times. Oh, God. The court suspended Jamie as conservator. Right. He didn't resign. The court suspended Jamie as conservator of the estate on September 29th and set a November 12th hearing to prioritize the termination of the conservatorship. Jamie filed a status report on November 1st, reaffirming his desire for the conservatorship to end. We went over that on the channel. On November 12th, the court granted Jamie's petition to terminate the conservatorship. The court further denied Britney's petition to remove Jamie as her conservator, finding insufficient evidence has been provided to grant the matter on calendar on this date based upon the reading. I need to go back through and look at that because that related to everything, but he wasn't removed because he was already suspended. I want to see what Rosengart has to say about that. Jamie retains new counsel to represent him in ongoing matters related to finalizing the estate of accountings and aiding in termination of the conservatorship. That says estate. Remember at the beginning of the motion when they said winding up both the conservatorship of the person and estate? Now we've just narrowed it down to estate. Great. Jamie employed Wilkie Farr to efficiently and effectively participate in the remaining probate proceedings, but not to the things he's subpoenaed for. But I guess that those are different things in their mind. Well, because they're the investigation into the finances that Rosengart's conducting, so it's fine. To wind up the conservatorship so as to fulfill his continuing fiduciary duties. The Wilkie Farr case team that Jamie is employed is headed by Alex Weingarten, a partner with over 21 years of experience as a trial attorney and possessing substantial experience in representing trusts, estates, executors, and beneficiaries. I don't think anyone's going to argue. We're not going to argue that Wilkie Farr is not qualified. We're not going to argue the qualifications. We're arguing whether James is a party or not. And also by Eric J. Bakewell, a partner with over 18 years of complex litigation experience and whose practice includes sufficient experience in complex commercial litigation and probate disputes. It's an interesting practice area to do both commercial litigation and probate disputes. That's just me, point of curiosity. Jamie's retention of the payment of attorney's fees is necessary for him to wind up his duties as a fiduciary. Okay. And again, no shade to the attorneys. They're being hired to do this. Wilkie Farr has expedited the transfer of all conservatorship documents to Britney's counsel at the request and direction of Jamie, and as is his duty. As of today, former counsel at Freeman Smiley has produced 58 boxes of paper records and 110,000 plus electronic documents totaling over 400,000 pages. Additionally, counsel at Holland & Knight released 2 separate productions totaling 5,000 electronic documents consisting of 23,000 pages. It's interesting to me that Holland & Knight has substantially less documents that have been produced. That's just a point of curiosity. It may mean absolutely nothing, but that disparity strikes me as curious because it was always my impression that they were lead counsel is all. Maybe Freeman was really dealing with most of the documentation. It's possible. Throughout the transfer process, Weingarten has aided counsel for conservator of the estate, Justin Gould, in obtaining the documents. Great. They're all working together. Fantastic. Oh, speaking of a lot of documents and the internet, now is probably a really good time to remind you that the internet is not always a safe and secure place, and thank today's sponsor. Before we get any further, I want to take a minute to thank today's sponsor, NordVPN. You know, I've been working with NordVPN for quite a while now, and that's because I believe very strongly in data security and privacy, and using a virtual private network is one of the best ways to secure your data as it flies through the internet. It also stops all those annoying ad tracking, and it also makes it so that you can use remote Wi-Fi when you are traveling and feel more secure in it, with whether you're at Starbucks, a hotel, an airplane. Those Wi-Fis aren't always particularly secure, but with NordVPN, you can connect through the virtual private network. It double encrypts your data so that it isn't being used for nefarious purpose. You can use Nord on up to 6 devices, and you can use it on everything from your phone to your desktop to your laptop to an iPad or other tablet device. Nord also has plenty of bandwidth and super fast servers, so it doesn't slow down your browsing, and they don't keep a log of your activity or your data. Not to mention, Nord has a 30-day money-back guarantee, so try it now for you, or get a Nord subscription for a family member. 'Tis the season for data protection and online shopping and not being tracked by those ads all across the internet. Not everyone needs to know my business. I do need a new table, but not everyone needs to know about it. Check out my link down below, which supports me and the show and also gets you a fantastic discount on a 2-year deal plus a free month. Huge discount. Big, huge, the best. www.nordvpn.com/EmilyDBaker. Once again, my code is Emily D. Baker, and you can just hit the link www.nordvpn.com/EmilyDBaker. Thank you, Nord, for sponsoring another video. Let's get back to our legal talk. We should just. I know, back to talking about James Spears. Thank you, Nord, for being such a fantastic sponsor. I think we've been working together almost a year now, and I really have enjoyed not just working with NordVPN, but with using NordVPN as well, except on Pacer. It won't let me do it on Pacer. My phone's talking to me. Stop, phone, shush. Phone. I have no idea why my video started playing on my phone. That was a little creepy. Just saying. Let's continue on with its document production. Let's go. All right. The need to immediately and effectively wind up the conservatorship and transfer the estate. Jamie owes compensable fiduciary duties to transfer administration of the estate to Britney's representatives, complete and finalize accountings relating to his administration of the conservatorship, and participate in the termination proceedings. I will be interested to see what Rosengard has to say. If that's true, to some extent, attorney's fees can be appropriate if that is true. I'll be interested to see the law behind it from both perspectives. Jamie's current suspension does not excuse him of fiduciary obligations and does not bar his right to reimbursement for fees, the law of equities, and public policy. When we're going to the law of equities and public policy, it really makes me believe that there is just nothing else to go with. Like, it really gives me the impression that there is no case law here to really cite, and we will see what they get to next. I've got to grab my notepad because I forgot to timestamp my swoops because I got into it too fast today. Because I was running late and I felt bad. Conservators owe fiduciary duties to conservatees like that between trustee and a beneficiary. As fiduciary, conservators are bound to act with prudence and pursuant to good faith belief, but you're not still a conservator. I wonder if all of this case law is about current conservators and not about past conservators. So let us see. Payment for fees incurred by a party seeking to protect the interest of a conservatee is warranted where the party caused a conservatee's estate to be safeguarded from possible dispensation. But that's not past. All right, we're going to jump through the case law here because I'm interested to see both sides take on the case law before we go through it. Reimbursement extends to fees and costs incurred by the fiduciary to defend their administration of the estate, but these are all cases pointing to the current, and it doesn't say suspended, but if legally the fiduciary duty extends, then some of this can actually extend. It's just whether or not legally that responsibility extends once they've been replaced. Jamie is entitled to compensation for attorney's fees and costs to fulfill his fiduciary duties, must continue to participate in the transition of the estate, finalizing the 12th accounting. What else? This is getting repetitive. The 13th accounting, winding up the conservatorship over Britney's person and estate. As to the person, no way. Oh, you guys are telling me I forgot the Nord link. All right, let me put it in. You guys are like, Emily, you forgot the things. Yep. Going in now. And that will get judged at the end of stream. I hate that when I link on YouTube, I have to put, you guys are like, Emily, we're professionals here. Totally. We're totally professionals. We're doing it live together. Flash Emily D. All right. Let us get that live. Y'all don't need to see all of the things. Let us get that live. Oh, I accidentally added an extra one. All right. Yay, there we go. Live. It's live now. It's live now. I promise. Let us get back to Britney. All right. We handled it live. Thank you, everyone. We're professionals here. Let's see. Each of Jamie's ongoing activities in this probate matter avers to the interest of Britney. But does it though? And Jamie's participation in these accounting proceedings is necessary to resolve any questions or doubts. But also then why avoid the depositions? If Jamie's position is really that this is necessary, that he's participating, that he's cooperating, if that's truly his position, then why not show up for the depositions and the document discovery? Why not? Why not? Why not? Ugh. I just. Oh, did I put in my code wrong? Y'all are like, did you put in your code wrong? Hold on. Professionals here. This is the stuff I normally prep. And with that, let me see, where is it? Let me find it so I make sure I have it absolutely right. Sorry, y'all. We're We're professionals here. Professionals. And of course, things are just going slow. So we're going to keep doing both things at once. Let's see. Where is our Christmas deal? Oh, you're right. It is Emily D. Baker. See, I already forget the things. We'll do it. And then I'll add the pinned comment afterwards. So we will do all the things. You guys are like, Emily, seriously. Yes, seriously. We're professionals. Thanks, Nord, for being patient with me. This is what I love about working with sponsors who know me, that they're just like, we've got you, girl. We've got you. We've got you. We've got you. Thanks, Danny. All right. We should actually let me just pin that real quick so I don't forget. I'll pin it while we're live and then I'll pin it again. So we have it because we so appreciate our sponsors, because we're already demonetized on this stream. I don't even know what I said. Maybe it was yeet that was so offensive. No, I'm trying to pin that and it won't let me. Oh well. Cannot pin. We'll try again later. Let's see if I can pin it from over here. I'm going to just keep going. And it's all going to be fine. It's all going to be fine. Let me pull this up and we'll just keep going. No valid question can be raised as to Jamie's continued participation. No valid question. I love that they've already framed, like if you want a masterclass in how to reframe arguments, they've already framed any objection by Rosengart as invalid, which is a really interesting framing if we're going to pick this apart from like a kind of a stoic argumentative point. If we're looking at like the pieces of an argument, the straw manning in here is kind of great, but also reframing the question into kind of a false premise is that any question is now not a valid question, which is kind of clever, but kind of funny. The question here is just what the law requires as to whether he's a continuing fiduciary. And I'm sure that's what Rosengart will argue. Jamie's entitled to payment on accounting of ongoing attorney's fees. Payment on accounting means they get paid 80% and then the court approves it later. So they get paid monthly. Jamie's entitlement to payment on account of attorney's fees necessary. Jamie's entitlement to payment on account of attorney's fees necessary to finalize the accountings related to his administration of the estate and to assist winding up is not affected by the conservatorship's termination, his prior suspension, or any of the unsupported attacks alleged by Britney's counsel through the media. Well, also in legal filings, they're in there too. Attorney's fees incurred on behalf of the fiduciary are chargeable to the state. If the fiduciary has been suspended or removed. That's what I was looking for. Case law. Holding that attorneys hired by a removed fiduciary to assist with the administration of the estate are entitled to a reasonable fee paid from the trust account. I will be interested to read this. It's not an old case, 2009, so it'll be interesting to see how that gets legally distinguished. But that's what I was looking for, is something that pointed to what continues. Because again, if this case is holding authority and his suspension does not change it, then he might be entitled to some attorney's fees legally. Even if we disagree and we're like, ugh, pay for yourself. He might legally be entitled to some. Narrowly construing what winding up duties entail will be important for Rosengart if Yeeted is entitled to some of these things. And that will become kind of the critical part. I'll be interested to see their response, which is why I've been leaning towards doing both motions together, like the filing and the response, so that we're not going piece by piece. The Spears motions, we're still going to go piece by piece because they are interesting. They go in to talk about this other case that are instructive in conservatorship proceedings. They say, was a trustee accused of failing to provide any accountings for over 25 years? Well, that's not good. And for making excessive payments to himself and his attorneys. So they picked like the worst possible scenario. The trust beneficiaries petitioned for an accounting to remove the trustee and to surcharge the trustee. The court removed him and ordered him to prepare an accounting from 1981 to 2005. Litigation ensued about the removal and the final accounting. The court granted the removed trustee's request for payments of attorney's fees from the trust assets while the surcharge claims remained pending. Interesting. I wonder how they'll distinguish that. Holloway Court similarly found reimbursement of attorney's fees incurred by a trustee defending against claims of misappropriation was proper. So the court allowed the trustee to get attorney's fees while defending themselves against claim from the trust. Okay. In Holloway, a petition was brought against co-trustee, claiming she breached fiduciary duties owed to the trust beneficiaries. The trial court granted the motion for summary judgment, finding no breach, and thereafter granted the petition for reimbursement of attorney's fees. I think they're distinguishable, but we'll see. So they've continued on to talk about why that case law is instructive and why it applies here, which at least there's case law seemingly supporting their position. Again, we'll see what the other side says about distinguishing it, because that's what lawyers do. Jamie anticipates Britney's counsel will rely. Oh, good. An arguendo. Look, the legal work is good. The legal work is good. We've got an arguendo. Jamie anticipates Britney's lawyers will do this. Okay. Will rely on People ex rel Harris versus Shine to justify barring Jamie's right to fees and costs incurred to carry out his remaining duties. The circumstances in Shine are an opposite. Again, distinguishing the case law. This is what lawyers do. Shine involved a criminal prosecution against former trustee, where the former trustee was awarded interim fees for his defensive claims related to malfeasance. In analyzing whether the fees were proper, the court set forth a two-pronged standard. That standard might be appropriate, though. That's a 2017 case, and that still might be the rule. No, regardless of the circumstances. Whether the trustee will ultimately be entitled to reimbursement for attorney's fees and the relative's harms to all interest in the litigation. That might be an interesting test. Let's see what they say in their footnote. The Shine court recognized that former trustee are generally reimbursed for 1, the preparation of an accounting, and I think that that's probably right. 2, the successful defense of an accounting. 3, litigation to preserve assets, and 4, the successful defense against a petition to remove. Isn't that interesting that the court allows legal fees if you successfully defend against a petition to remove yourself? That's very, very interesting. But if that court applied the test and found that the preparation of an accounting and the successful defense of an accounting were proper, then these fees might get granted for those limited purposes, and it might be legally proper to do so. Again, legality, morality, two different things. And Britney could perhaps end up paying fees for those narrow items. I'll be very interested to see what Rosengart says. There's no teeth to the allegations and charges asserted by Britney's handlers, counsel, and supposed allies regarding James' administration of the estate. Jamie dedicated his life to protecting his daughter. Oh, there's the Britney's daddy loves her, just said in a less creepy way. No one can point to any wrongdoing regarding his administration of the estate because no findings have ever been made against him. I think Rosengart's response to that will be, yet. We're working on it, but we'll see. Notably, every action that Jamie took as co-conservator of the estate has been, okay, that's just getting redundant. It's been reviewed and approved. No one objected, we know. Jamie must fulfill his fiduciary duties. That's also redundant. That Britney's why are we just repeating ourselves? I mean, you're not me. I repeat myself all the time, but I'm contemporaneously live and there's no editing. We're talking. You have a chance to edit this. No need. They go on to say that Britney's counsel alleges wrongdoing and tries this case through the media is of no moment. Okay, so Britney's attorney is now trying this case through the media. That's an interesting perspective. I wonder what that feels like. I mean, maybe because they're new counsel, they see it as they're completely dissociated from prior counsel being on a documentary. But okay. Well, okay. That's an interesting positioning. Jamie's entitled to reimbursement of fees. The court should authorize payment on account. We've already gone through are we arguing this again? We've already gone through authorized payment on account. Should be paid on account on the same terms. We know what the terms are. Let's see. The court orders authorizing payment on account to law firms are, and then they list all the times the court has authorized payment on account. From the early days through the Sam Lufty litigation, et cetera, et cetera. And then they bring in Britney's attorney's fees too. Each of these orders authorize payment of 80% of attorney's fees billed and 100% of cost advance, with each of these fees reviewed and approved to allow and allowed on a periodic basis. Consistent with prior practice, the court should confirm, authorize, and direct payment on account to Jamie's newly substituted counsel, Will Kefar, which is representing Jamie in an ongoing proceeding. We know that that's their argument. Jamie is entitled to the same payment account that's afforded to Britney's counsel. Okay. The rules of equity require that all parties' attorney's fees be paid on account on the same terms. Parties, who's a party? They're going to be arguing over who's a party and who's not. There's no prejudice to the other parties by extending Jamie the same agreement they are afforded, except to they could argue to Britney, but okay. There's been no prejudice to Britney in granting and ordering authorizing payment on account of Jamie's fees, because the court will ultimately review the payments made to each party's counsel and confirm Britney's estate is protected, and can make orders clawing back excessive or inadequate fees. The interests of equity require it. Public policy require. We're not even getting into the public policy. Once we've gotten to the public policy argument, I'm out. It's like, okay, if you believed in your position, do we need to get to the public policy argument? Like, why include that? Your Honor, it's in the interest of justice that Britney pays her daddy's legal fees. Okay. Every action Jamie took as co-conservator was made with the utmost care and concern for his daughter. He volunteered to act as co-conservator in 2008 to save her from physical harm and financial destruction when no one else would, after he received a loan from TriStar, according to the New York Times. Alleged, I should say, by the New York Times. Jamie worked hand in hand with the court, including the Honorable Reva Getz and the Honorable Judge Penny, his co-conservator Wallet, court-appointed counsel, to ensure Britney's best interests were protected. He also negotiated himself, according to court documents, at least a 1% fee as the conservator when she went on tour, which seems to be completely inconsistent with the role of a conservator. But all right, go off. It would be contrary to public policy if Jamie's years of dedication to protect his daughter, conducted with the oversight of the court and in concert with others. Yeah, in concert with others is probably the most accurate term. In concert with others isn't necessarily a good thing. In concert with others is also like the foundation of a conspiracy charge. But I'm just saying, the conspiracy to commit the thing happens in concert with others. I'm talking about the Maxwell case. Clearly not this case. No conspiracy has been alleged or charged here. I'm just saying the languaging in that is interesting. The in concert with others is very interesting wording. It would be contrary to public policy if Jamie's years of dedication to protect his daughter could subject him to personal bankruptcy and ruin defending baseless claims. Where'd the money go, though? I would love to see how much he made on this conservatorship. He got a salary. He got his lawyers paid. He had a storage unit and an office. He got more a month than Britney did. He got 1% of her tours. So where'd the money go? My question. Your Honor, he'll be bankrupt. No person would ever want to step into the role of conservator. Oh, this is the public policy argument. If you ruin James Spears, no one will ever be a conservator again, and the entire system will collapse. It's a bit much. No person would ever want to step into the role as conservator if a conservative could force a conservator to personally pay substantial legal fees defending against unfounded allegations. As the appellate court observed, attacks on conservators are often misdirected and ignore the good bestowed upon the conservatees. It is a sad feature of conservatorship proceedings that conservatees are sometimes unable to comprehend. Oh, wow. Okay. Unable to comprehend the good intentions and deeds of others. As a previous court observed, quote, the individual who first suggests the need for a caretaker like a lightning rod often attracts to his or her person the lasting wrath and suspicion of the supposed incompetent. Okay. Jamie should not be required to sacrifice his personal well-being. His personal well-being? Wow. Jamie should not be required to sacrifice his personal well-being. His personal well-being. Mhm. Mhm. He said that. Defending his administration of the estate, where each of his actions have thus far been made with counsel and the approval of others, including the court. Everyone that's getting served, all the things. And then there's a declaration. We're not going to get into all of the declaration. I'm just going to show you the declaration. This was only 27 pages, and that took an hour. The declaration, oh, I'm sorry. Hyperbole got me. The declaration, y'all, is only 600 pages. We're just going to go through the list of what's in here because this is the one with attorney's fees. Okay. This has been an interesting, just wait, we've got more to go today. We've got more to go. We're going to get into the Johnson lawsuit next, and there are really no words. This is the declaration of Alex Weingarten. I will say the lawyering is excellent. The fuckery is real because my position has been clear about some of this stuff. I've made my position clear, but the lawyering is good. These lawyers are paid to vigorously represent their client, and they are doing that. The writing is clear and concise. The legal precedent they are citing seems to be on point. We'll see what Rosengart has to say. I'm not site checking their work. That is not what I'm here for. I'm sure they all get paid more hourly than I do. Maybe not. We'll see. But I did have somebody on Twitter offer to be my sugar daddy for $300 a week yesterday. So that was exciting. So who knows? The possibilities are endless. But what's interesting is that even if we are opposed to the position and we're like, this is just fuckery, the lawyering is very good. And the way that they are positioning their arguments is very good. So if you want to look at the good legal work of it, look at the good legal work of it. The way that they did the IRAC format was it was good writing. We're like, but the fuckery of it all, but zealous advocacy. So we are definitely not going to shade the lawyers because we don't agree with the position, because the legal work in that motion was quite good. But we all are like, don't rile the Rosengart. Their legal work has been quite good too. And the underlying sadness of this case is that Britney is paying for all of this to happen. But I think with Rosengart's response, we will see some excellent lawyering in this it's one of the things I appreciated about the Duggar case. We saw some really, truly excellent legal work. And we can all, we point and laugh at kind of the Triller lawsuits, but we can all look at this and be like, oh, the repositioning of it all. But it's well done arguments and well-crafted arguments. So Alex M. Weingarten, you're declaring things. Spears retained you, we know. This is going to be a resume because they are arguing for legal fees. It's not inappropriate. They're arguing for legal fees. Partner at Wilkie, counsel to Mr. Spears, graduated from Georgetown Law in 1999, more than 21 years of experience as a trial attorney, probate, entertainment, intellectual property, and general commercial litigation, substantial experience in representing trustees, which is good for them. Selected as a Southern California super lawyer for each year from 2014 to 2018 and 2020 to 2021. Selected as one of the top 20 lawyers in California under 40 by the Daily Journal. The Daily Journal is a legal publication. In each year from 2016, selected as a finalist for Leaders in Law. You are very impressive. Let's see. I was named among the top 50 litigators in LA by the LA Business Journal. A publication also named me as one of the 500 most prominent business lawyers in Los Angeles. I've been named a top music lawyer by Billboard magazine, and one of the top entertainment lawyers by Variety. Hey, that publication keeps coming up. Also, I think that Rosengart gave a statement to Variety about this. We'll get into that in a minute. My practice focuses on matters of significant depth and sophistication. We don't doubt you're an excellent lawyer. There's a true copy of the bio. Fantastic. We get the whole bio. Oh, but your phone numbers are in the bio. Well, Los Angeles Business Journal, California Daily Journal, Variety, and Billboard, clearly a lawyer with a good resume that did good legal work. Let's see, which means he is probably going to be in the ballpark of what we were seeing from Viv. Oh, here we go. I'm familiar with the hourly rates charged by Wilkie for its attorneys. The hourly rate for Bakewell is $860 an hour. My hourly rate is $1,200 an hour. This is going to be high for a lot of you across the country. This is not crazy in Los Angeles, but that's also why this attorney is not just like fluffing his own aura with this. He is actually sharing the things that are the foundation of why his rate is $1,200. And that's probably not an exorbitant rate given the expertise, the area, the area of practice. So for Los Angeles, for a lawyer with this experience and this practice area, that's not insane. That might feel insane, but that's not insane. So we're not going to shade their hourly rate either, based on that experience. So whether the court will approve that hourly rate or not is another thing. So, based on my experience and research, so this is talking about the hourly rates because they have to defend their hourly rate to the court too for that hourly rate to be approved. I'm sure Rosengart is going to object to all of it. Transition of the conservatorship. So they're talking about the work that they've done. Factual background of the petition. Here's the list of exhibits. This is what I wanted to get to. Mr. Spears' petition for appointment of probate conservator. We've already gone over that ages ago. Temporary conservatorship of the person. Court's letters of conservatorship. I will just say, not all of this is needed. The court file is aware that a conservatorship was put into place. These orders from 2008 and 2009, are they really needed? Court's order approving the first accounting. I guess what they're trying to show and continue to try to show is that all of the accountings were approved, but it's on the court record. Like, you don't need to attach it. I will be going through all the attachments. This is why it's 600 pages. Because all of these are attached. First accounting, approving the second accounting, third account, fourth account, fifth account, sixth account. I mean, at least I don't have to go pay for all these documents, I suppose. I already just paid for this one. Seventh account, approving the payment of conservators' attorneys from 2017, approving the payments on account 2017, the similar orders from 2018, approving the 8th account, the 9th account, accepting the resignation of co-conservator from 2019, temporary conservator of 2019, that would be Jody Montgomery, conservatorship of the person, those are the letters for Montgomery, approving the 10th account, the 11th account, settlement of the 12th account, that's the whole motion that's been objected to that's still going, that was filed on August 6, 2020 and is still not resolved yet. Order associating litigation counsel from 2020, order associating litigation counsel from October 2020, Loeb and Loeb's notice of association. These are all the other orders authorizing other attorneys. See, Your Honor, you authorized them. Petition for suspension or removal, termination of conservatorship, ex parte order authorizing and instructing payment to counsel from 2021. That's the older motion. Jamie's ex parte application for instructing payment. We've gone over those payments. Those are with regard to the other lawyers before this group signed on. Support in termination. These have all been on the record and we've covered them. True and correct copy of the minute order granting the petition for termination. We've gone over that. order denying Spears' petition to remove. That's the one we want to get to, Exhibit 39. Let's go take a look at that. We're going to Control F ourselves into Exhibit 39, and then we are going to bounce to another topic and then get to questions because there is more fuckery afoot. Exhibit 39. Let's go to the next. It worked. Yay. It just made it so easy. This is from November 12th. Petition removal filed on July 26th. The court, that's what it says. The court having ruled on the related termination petition on calendar this date, hereby rules as follows. The court finds insufficient evidence has been provided to grant the matter on calendar. That's what it says. The removal filed on 7/26/21 is denied without prejudice. Interesting that the court didn't say that it was moot based on the suspension, but the court finds insufficient evidence has been provided. That is, in fact, what it says. There we go. Whoop, there it is. All right. We are at an hour and 15 minutes in, and it is time to switch over. If you are here because you are curious about the Chalene Johnson lawsuit, go ahead and pop a 1 into the Chitty Chitty Chat Chat. If you're like, girl, what are you talking about? Pop a 2 into the Chitty Chitty Chat Chat. I am curious to see just who's here for what. And I'm going to go try to pin this comment real quick. For Nord, because it's going to distract me and I'm going to get focused on it. And if I get focused on it and I'm distracted, I will not be able to move on because your girl's ADHD, and that happens. That happens. So we're going to just add that. I love seeing you all in the chat being like, we got 2s up in here. Hold on. Let me try to pin this. All right. We got some 1s. We got some 2s. Lots of 2s. Lots of y'all are like, who are we talking about? Don't worry. I'll give you the background. Let us swoop and we will talk about it. So for brief way of background, Chalene Johnson is a social media personality, marketing expert. She runs something called Marketing Impact Academy, is very well known in both fitness circles and entrepreneurial circles. Her son is also like an Instagram trainer, Instagram expert. You got to remember, I come from the world of online entrepreneurship. That when I left the DA's office, that online entrepreneurship world is what I jumped into head first. So, the Amy Porterfield, Pat Flynn, Chris Ducker of it all, Chalene Johnson is very much a big part of that world, and has courses and live events. I've been to one of her live events with a lot of friends. She and I have mutual friends. She and I have talked about ADHD and other things. So we know each other in a collegial way. But in covering this lawsuit, I am covering this not just because we've covered a lot of defamation, but because I think defamation suits with regards to social media personalities are very interesting. There's a lot of analogies that can be drawn with the H3 lawsuit, even though the situations are different. So a lot of you asked me to cover the Chalene defamation lawsuit with her plastic surgeon. And that is part of why I'm covering it, because the law nerds have been like, girl, have you seen this? Especially the law nerds that know me back from my entrepreneurial days. So some of you might have found Chalene through like fitness instruction with Pio. Some of you may have found Chalene through Marketing Impact Academy and other things, but we do have mutual friends. And I am very much aware that as a human, Chalene is somebody that I very much like. And I will be making that caveat as I cover this. That doesn't mean that she has, because the second a lawyer covers stuff like this on YouTube, we saw this with Attorney Tom, and we've even seen it alleged against me. The second you cover something, people are like, you're on the payroll. Not on the payroll. Chalene has not asked me to cover this. This is something I'm choosing to cover because A, it's important to the space of online influencers and those with independent platforms. And the law nerds have asked me to cover this quite a lot. And when there is something of interest to the community, I am fascinated by it. So given that, I will make sure that I am clear with you where I think, again, if I think something is strong, or if I think something is strong for the person suing her or for her, I will absolutely tell you, because I can distinguish between liking Chalene and this lawsuit, because lawyer. So I wanted to just make that clear as we cover this um, because A, authenticity and transparency with y'all, and B, because you will hear me say throughout, I've listened to her podcast on some of these things as I was doing research about this suit. But this originally came to my attention because of her podcast and listening to her story on her podcast. I was initially interested because I have had friends who are also in the social media realm go through things with surgeries and come to me saying, I want to tell my story as a legal consultant, which is why I'm not disclosing who, but come to me saying, I want to share my story, but I am concerned that my plastic surgeon will sue me if I share my story honestly and my experience honestly, even though my story is not necessarily about my surgeon. People who had negative results, not because of their surgeon, but because of the type of surgery that they had that, again, had I known everything I know now, I wouldn't have made this choice, not on the doctor, on the type of surgery and on the thing that I did, but being concerned because lawsuits in this space are very, very common. And so I've consulted with people who have had these questions of, I am in the realm of sharing my life with people. I want to share my life with people in this regard, but I don't want to get sued either for speaking my truth. The thing about defamation is anyone can sue anyone for anything, and lawsuits are allegations and shade, and the truth is a defense. But the truth is a defense that comes at a cost because you can absolutely be 100% right and spend hundreds of thousands of dollars, if not more, to prove that you're right. And at the end of the day, yes, you can get attorney's fees back most of the time, but at what cost to your personal finances, your health, and your mental well being? Which is why a lot of people absolutely just say it's not worth this smoke. Chalene is in a place where it seems that, and I've not researched her net worth. I've never asked about that kind of stuff, but somebody who has sold programs to Beachbody, runs large events, and seems to have the financial wherewithal to fight this fight and is choosing to. So we're going to talk about it from not just what the doctor has filed against her, why, and then her responses to it. And we will continue to cover it because, again, this doctor is saying, but because you have a platform, you can't speak out. Chalene's side of it is, this is the truth, and I am allowed to share my truth, and I will. And what you're not going to do is make me shut the fuck up. So what was interesting to me is that he chose to serve her while with the lawsuit, while she was at like a fan meetup with her community in New York. So with all of that, there are a lot of analogies to people with platforms speaking up and where are the boundaries between defamation. And this touches on that. Same with the H3 suit. So if you're following the H3 suit, I see a lot of parallels here. The H3 suit deals with reviews in the App Store. This suit has some tangential relation to reviews on Yelp. I have a podcast episode that I'll link below when I remember regarding getting sued over Yelp reviews. It is something that has been increasing. I will also say we will be going through some declarations that are medically specific. We will not be going through the images connected. The images connected with some of these she has made public, and I will link her podcast episode where she has made these documents public, and I will link that. She has chosen to make them public from what her lawyers have filed. I will not be sharing those on the YouTubes. Not everybody can deal with graphic medical images, but if you want to, they have been made publicly available. It is a public lawsuit that you can go see them. Also, not a doctor, married to a maxillofacial prosthodontist, but is governed by the dental board, not the medical board. I will be possibly reaching out. I've got some questions for Christina Brawley, and I am going to try to reach out to her. And she is an anesthesiologist here on YouTube, and ask her about some of the things in this lawsuit to see if she has any input for me from her perspective, to just get the analyst, the medical analyst, the legal analyst, the commentator brains all going on this, because I'm curious about her perspective. And with that, we should just get into what is being charged. Chalene Johnson, again, I will link her stuff. She has shared this journey on her podcast. You will see that discussed in the complaint. If you want to know her side of it, you could absolutely go and listen to her side of it because she's shared it and she's getting sued over sharing it. But let's get into it. I am skipping directly to the first amended complaint. The complaint from the doctor is substantially similar, but this adds more. So there's no point in going through the complaint and then going through the amended complaint, because the amended complaint adds more detail. So let us see. I will reach out. I'm sure there is medical commentary YouTube. I will find the others. Christina is the one that I watch. So she is the one that came to mind because she is an anesthesiologist, and anesthesiology comes up in this, and I would love to hear her thoughts. I also been watching her channel for as long as I can remember, and the only times I have to pause watching her channel is when she makes me like she shares things and I'm like, I should buy that. I'm like, no, girl, no, you shouldn't. What you're not is an anesthesiologist. What you're not going to do is go buy the things. Stop it. Because she does share quite a lot of luxury. That's not where we wanted to be. All right, there we go. I was trying to make this bigger for y'all. All right. Dr. Malavi is also referred to as Dr. Laguna. I may switch between the two. That is his social media handle. He is also somewhat of a social media personality with over 100,000 on Instagram. So if you want to check out his Instagram as well, we're getting more of his side of the story through his responses on Yelp and through his legal filings, but you're welcome to go check it out. As always, we are not going to disparage people in the chat. I know it shouldn't be a problem with this topic at all, but also there are harassment charges here that Dr. Malawi has been receiving death threats and people threatening and harassing them. And I say this when I cover the H3 stuff too. You don't help your favorite by going after the people that they are in litigation with death threats, with threatening behavior, with fake reviews. That always makes it worse, and it can make litigation more expensive. I know Chalene has spoken out about that. I've seen Ethan speak out about that. And I guess as I'm covering this, I feel that it's also my duty to also say, sending hate to anyone involved in this makes it more expensive for everyone involved and is just not okay. You're welcome to pick sides. You are welcome to evaluate these and see what you think about the allegations. Did someone go too far? Is the lawsuit total bullshit? Make your own determination as we go through this, but do not contact the parties involved. You can go watch what they're doing on social, but stay out of it. That's all. Death threats are always bad. They're illegal. Don't do that shit. The law nerds don't do death threats. We know this, but just in case somebody's scrolling by that doesn't know that, we will say it again. So the complaint is for defamation, false light invasion of privacy, IIED, intentional infliction of emotional distress, which will hereinafter always be IIED. It's interesting that they didn't also file negligent infliction of emotional distress. Like, if you're already doing the IIED, I don't understand the choice to not just go with the lower one, the negligent infliction, but okay. Interference with prospective economic advantage. This is also involved in the H3 suit. Harassment and violation of Code of Civil Procedure. Now, after this lawsuit was filed, this amended complaint was filed November 1st. After this lawsuit was filed, he has also filed a motion for a civil harassment restraining order. And and there are some responses to that we will go over to, because there's an answer and then there's answers with regard to the civil harassment restraining order. Chalene did a podcast episode about the court hearing. It's been substantially put over as the court goes over the law and has set this for another hearing date. Statement of the case. This, we love a strong sentence. I will just say I've gone through this. This is not a first look, so I'm not going to go through all of it. But this is very clearly and concisely written. This is not a cluster of a lawsuit. And while we might not always agree with the positioning, the legal work in here is not a cluster. It is very clearly written and concise, well, mostly concise, but it is a well-drafted complaint, in my opinion. But it was also drafted with an awareness that this could or would end up on social media. This is an unfortunate case where social media personality Chalene Johnson, under the guise of helping others, has weaponized her marketing experience and social platform of 700,000 plus followers by exploiting a falsified medical experience with plaintiff Dr. Malawi for her own financial gain and notoriety. I see it as a false premise because there's a lot of people that just want their social media influencers to talk about the happy stuff and really don't want to hear about the negative stuff. But okay, we will see. Um, we will see. With the goal of destroying Dr. Malawi's career, despite having an admittedly successful surgery, Johnson has become, quote, obsessed, end quote, with Dr. Malawi's practice of medicine and with utilizing a false, sensationalized version of events, which she exaggerates and progressively changes with contradiction, apparently to keep creating new social media content for her public platform and podcast. It is a long sentence. It's true. Indeed, Johnson, a self described marketing expert, must have quickly realized that her online presence for the entire year peaked between August 15th and 21st. I'm just curious as to what they determined to be peaked and how they've determined that. Is it podcast downloads? Is it followers? Is it Google searches? Like, how do they determine peaked? The exact number of times she began the exact period of time she began defaming Dr. Malawi on her social platforms and podcasts, with the number one Google search result being her podcast about her surgery. I will say that in the first podcast episodes, she does not name this doctor at all, but they will get into that in this complaint. With, let's see, as such, continuing her online attacks on Dr. Malawi is proving to be great for business. I mean, I feel like it's speculative, but again, it's their lawsuit, allegations, and shade. Unsurprisingly, then, Johnson escalated her online attacks against Dr. Malawi from September through October 2021, adding more defamatory and sensational allegations against him, all of which are false and misleading, they say. In between these attacks, which have been generating high views and increasing her follower base, high views on what though? Because on a podcast, it's downloads. High views on Instagram? I mean, because I remember she was supposed to do a podcast with Heather McDonald, and the episode either went up and then came right back down or didn't even go up. It got advertised and didn't go up. So not everything is up and up. I think that some have not wanted to have her on talking about this. I would imagine because Dr. Malawi's people reached out and said, hey, what you're not going to do is interview this person on your podcast because you're spreading things. We're covering public record. And then if you guys want to see what everybody else is doing on social, you can go find it. In between these attacks, which have been generating high views, again, I don't know what they mean by high views, Johnson has strategically promoted her podcast, marketing course and offerings, and even sleep supplement products she's selling. I mean, okay, it's her business. I don't see that as shade because, okay, that's her business. You guys can let me know what you think. Such marketing and sales tactics are not obvious to followers who become emotionally invested in the falsities Johnson is asserting about Dr. Malawi. While these manipulations have been profitable to defendants, I mean, they presume, but okay, they have resulted in Malawi's entire career and livelihood being damaged by someone who has crowned herself judge, jury, and executioner with a secret improper motive. Is the secret improper motive, I mean, are they saying it's is the secret improper motive to weaponize her marketing experience and platform to exploit a false medical experience for her own financial gain and notoriety? Because I think that's what they're alluding to. To make matters even worse, since the initial filing of this action, Johnson has escalated her attacks against Dr. Malawi, his wife, and staff, targeting them directly, inciting her followers to act against him by, among other things, identifying his wife and employees by name and photograph, as well as publicizing his business address, phone, and office. Okay, but the thing is, though, he has a website linked to all of his social media accounts. You can't say look, if you are a public figure, which I am going with Dr. Malawi with over 100,000 followers on Instagram, is a public figure, your office and your business name are public record. So Okay. Such repetitive harassing acts have resulted in Malawi receiving death threats and countless harassing, degrading, threatening, and offensive messages, which is never okay. But are they coming from Chalene, is my question. And communications which have caused him severe emotional distress. Dr. Malawi is a board certified successful plastic surgeon, sought after by patients all over the country, has built a superb career spanning 17 years, is known and respected for his reconstruction, high definition surgeries. That's a whole thing we'll get to later, and is responsible for training dozens of other physicians in the field. Johnson sought Malawi's care in July 2021 and elected to undergo plastic surgery with him. Johnson's surgery was conducted without complication, and she raved about her procedures, stating publicly, "I'm quite happy with my results." I don't know if I'm quite happy with my results as a rave, but you can decide. Despite this, Johnson then began utilizing her monetized social media accounts. But the thing about defamation is it causing you harm? That's the key to this. I appreciate why they keep trying to paint this as monetized and weaponizing and all of it. We're seeing the same thing in the Kavanaugh lawsuits against Ethan Klein. It's like, but it's a monetized platform. Okay, but that's how this works. That's how social media platforms work. Okay. So I'm quite happy. Doesn't sound like a rave to me, but okay. Despite this, Johnson began utilizing her monetized media accounts and her for-profit podcast. Okay. Would it be different for them if there weren't sponsors on the podcast? Like, would that make a difference? Because that's not an element of the offense. In doing so, and under the guise of helping others, all while furthering her social media business at the expense of Malawi's livelihood, Johnson single-handedly spread false, defamatory, misleading, and damaging information about Malawi and his practice through her online followers, through multiple defamatory postings and statements. Oh my God, take a drink every time defamatory is said. We understand that's what you are suing for, which caused him and his family and staff and patients to be bullied, harassed, and threatened on a regular basis. Defendants' acts have only escalated to dangerous levels and resulted in threats and harassment, where now Malawi and his family and staff fear for their lives. Which, again, harassment never okay. Johnson also interfered with patient care, and her defamatory conduct has directly damaged Malawi's practice. There's the allegations of damages needed for defamation, as current and potential patients have canceled their procedures or treatments believing Johnson's false and heinous allegations. So different than the Kavanaugh lawsuit, there is an allegation that current patients have canceled procedures due to these statements. Again, that's what they're looking for in the Triller suit. Did current Triller users delete the app or stop using the app because of what Ethan said? They're saying, and I imagine down the road, we will see if it's an accurate claim, we will see a declaration of someone saying, I canceled my procedure based on this podcast. But again, that only counts if the statements are false. And that's really what this whole case is going to boil down to is, are the statements false or are they not false? If they're not false, it's a defense. If they are false, then it's not a defense. But you would expect to see down the road declarations of patients who canceled their procedure because of this, or said when they canceled it to the front desk. I don't know how you would verify that other than bringing them in to testify. I canceled because of this. But that is at least an allegation of direct harm and the direct basis for the interference with economic or economic relationship, because you had somebody that was booked for a procedure who canceled. So at least the damages are more clear than the other defamation lawsuits that we have covered. So there is, in fact, that. Johnson has ignored Malawi's invitation to discuss and sort through her concerns and elected instead to exploit his silence and patience, revealing her true motivations. Again, lawsuits are allegations and shade. Team Johnson LLC and Team Johnson Inc., which operate and distribute, did they sue both? They only sued one, though. Why name both if you're only, like, Team Johnson LLC's name, but Team Johnson Inc. is not named, so why name them down below if they're not a named defendant Just a point of curiosity. Because my brain was like, wait a second. I only saw one company. Operate and distribute the podcast have directly benefited from the distribution of at least 4 defamatory and misleading podcast episodes about the doctor, and continue to do so as they are available and have been viewed thousands of times. Just for clarity, podcasts aren't viewed. I don't know why I'm so bothered, but I am. So the deplorable behavior of defendants who are monetizing their social media presence, they're very hung up on this. It doesn't legally matter. Who are monetizing their social media presence at the expense of Dr. Mallory, or have always monetized their social media presence, because that's literally how that works. It cannot go unchecked. Defendants' defamatory media campaign intended to destroy Malawi's entire livelihood is the very definition of defamation per se. Defamation per se, again, being that something is so defamatory you don't even need to prove damages. But here they're already showing the damages. So how did they allege defamation? They just allege defamation. They can go under either a standard defamation or a per se theory, but it seems that they're already arguing that they can prove damages. Again, it has to still be a false statement. We're not even to venue yet. Hold on. Johnson's harassing conduct also threatens the doctor's health and safety and that of his family and employees. Plaintiff therefore brings lawsuit for the damages they have suffered and will continue to suffer as a result of the misdirected and defamatory conduct, and enjoin defendants from repeating their defamatory statements and otherwise continuing their unlawful conduct. So the injunction is that permanent injunction, and they've also filed a civil harassment restraining order. Parties and venue. The doctor is a doctor in Laguna Beach. The surgery center is the business. Team Johnson LLC is the LLC that operates the podcast. Plaintiffs inform and believe that Team Johnson Inc., previously identified as Doe 1, is all relevant times here too, a California corporation. It's interesting that they added them, but didn't add them to the title. So it looks like they've added that this was previously Doe 1. They've added Team Johnson Inc. to the lawsuit, even though they don't list them as a plaintiff up above, but they're listing them here. Does 2 through 20 are also listed, they say. And of course, Chalene as an individual. Everybody lives in California. Jurisdiction isn't going to be an issue. Blah, blah, blah. Summary of key factual allegations. Johnson pursues Dr. Malawi for plastic surgery and is happy with her results. It's an interesting way to phrase that, but okay. They go through his history. He wrote a book called High Definition Liposuction. He maintains a practice. This is the resume part of the plaintiff's filing, which is something that we absolutely get to in every single lawsuit. He maintained near perfect ratings on online patient review websites, including Yelp, Real Self, and Google. Johnson sought out Malawi for purposes of receiving his medical care on July 7th, 2021, had a consultation with him about the types of procedures she wanted to have. And again, she shared all this on multiple podcast episodes as well. Johnson was advised of the inherent risks of the surgery, the need for postoperative care. She did not voice any concerns. On July 20th, she returned for another meeting with him in his office in preparation for the surgery. During this appointment, her surgical plan was solidified. She appeared comfortable and looking forward to procedures, did not voice any concerns. Again, someone can change their mind, but I understand that they are laying the scene of this was all their perspective of this was all contrived later for clicks and views is essentially what they're arguing. On August 2nd, Johnson came into the office for the surgery. Prior to the surgery, the team prepped her for surgery, included marking the body for intended incisions. This is standard practice. Given the locations of the 2 intended procedures, had to undress for the marking and surgery process. That's not uncommon. The surgery was conducted with proper care and was completed without any complication. A week after surgery on August 7th, Johnson took to her Instagram account, which boasts more than 700,000 followers, and monetizes content. Again, obsessed with the monetization. But with him, he uses social media to promote his practice too. So I don't understand the obsession with the monetizing. I don't know if they think the court's going to be like, oh shit, it's monetized. That does make it defamatory, because that's not how that works. But all right. I don't know why they're so hung up on it. I just don't understand. To post a photograph of herself smiling with a thumbs up and a caption that informed her followers that she was home recuperating from an elective cosmetic surgery, she invited viewers to go to her podcast, The Chalene Show, where she provided more information. August 11th, defendants disseminated a teaser short podcast episode titled Plastic Surgery Advice, and Johnson further informed her fans and listeners about her surgery, stating, "I don't have any complications. In fact, I'm quite happy with my results." She then proceeded to state that she was unhappy with the experience. Again, that's not defamatory. That's an opinion, and two things can be true. Because two things can be true. And had recorded a longer episode with more detail. In this episode, Johnson states that several people on Instagram asked her to confirm which doctor it was, and she said, "I confirmed that it was that doctor." She indicated that she had a responsibility to contact the office, and they've taken it seriously. They were coming to her house to address her concerns. She further said she was going to pause on public discussion because I've shared so much that I could probably get myself into real trouble. So she was mindful of sharing her experience. But again, so far, allegations of defamatory, but we haven't gotten to the statements yet, and we will. I'm sure we will. Johnson's concern appeared to be that during her post-operative care with a massage therapist from the practice, she requested new body foam, which had been custom-made and fitted to her upper body post-surgery, and felt that the therapist denied her request. It was interesting because on her podcast, she said her request was denied, and here they say she felt her request was denied. But again, lawsuits. The doctor and his team went to her home for an in-home visit and provided her new foam. The visit went smoothly as Johnson appeared pleased with the procedure and the care she was receiving. Defendants proceeded to engage in multiple repetitive defamatory acts. Here are the alleged defamatory statements, I think. In a sudden turn of events on an August 13th podcast, defendant released My Plastic Surgery Nightmare. Johnson proceeded to describe her plastic surgery experience in a manner different from how she had before, alleging information that she had not expressed to Mawabi or anyone at his practice or his staff before her procedures. Specifically, Johnson falsely and maliciously implied that Mawabi somehow had negative online reviews removed and that she was unnecessarily told to undress, and that she did not like his bedside manner or personality. I don't know how any of those statements are going to fall. I mean, we're going to keep going, but for those statements, she did not like his bedside manner is not defamatory. It's a statement of opinion. Implying that he had somehow removed negative online reviews, I don't think is defamatory either, unless we'll get into further. And that she was told unnecessarily to undress is also her opinion. She felt it was unnecessary. So we'll just continue on. On the August 13th podcast, she maintained that she was not making any accusations about the doctor, reiterating, "I'm happy with my results. I did not have any complications." You can be unhappy with something and not have any complications, but okay. "I seem to be healing well, and I'm not taking any issue with my results or the doctor." On the same day, however, Johnson took to Yelp to post a negative 1-star review. Okay. She admitted, "I do not have complications. I do not currently have a problem with my results. And my current surgeon taking over post-care says it looks like the work done is satisfactory." Despite these good results, Johnson proceeds to trash Mawabi, writing that Mawabi was quick to tell me that my ass needed a lot of work, aggressively grabbed my C-section scar, has absolutely zero respect for women's modesty or dignity. He constantly orders you to, quote, "get naked." Okay. "I requested new surgical foam and was denied." Okay. Still, I don't know how any of these statements are a problem yet, so we'll keep going. Unsurprisingly, Johnson then invited the Yelp readers to her podcast, which defendants had just released, for so much more detail about her, quote, experience. Each of the Yelp statements were false. Well, their opinion, I mean, he either grabbed her stomach or he didn't. I guess that's aggressively being the opinion. He either told her ass needed a lot of work or he didn't, but that's not defamatory. Zero respect for women's modesty or dignity, constantly orders you to get naked. I mean, are we attributing harm to that statement? Okay. Each of the Yelp statements were false. More than 11,000 Yelp users have seen and marked this Yelp review containing the Yelp statements useful. Mallory responded to the Yelp statements acknowledging her satisfaction with the procedure. The two things can exist at once, clarifying that she did indeed receive new foam and alerting, but at what point? Because the request can be initially denied and then fulfilled. Two things can be true at once, but okay. And alerting her that her use of her extensive social media following to build engagement at the expense of him, his family, practice, and career was damaging him. Johnson neither responded nor stopped the outlandish conduct. Outlandish, by the way, these things go to false light. The beyond normal conception, it goes into false light. 2 days later, on August 15th, Johnson posted on Instagram a series of posts entitled Open Letter to My Plastic Surgeon, where she claimed that Dr. Mallory ordered female patients to get naked when it's not necessary, groped a woman's body and suggested she needs additional surgeries, paraded postoperative patients in pain on painkillers, fully nude, and invited other staff and client consults to view them with no right. That seems like it just drops off. Denied sterile dressing change. Use the moment a patient is standing naked being photographed before surgery in a room with 3 men to upsell additional surgeries. The August 13th Instagram statements were viewed by thousands of Instagram users and have garnered at least 1,748 comments. I wonder if that is a reel that's still up, because if it was just a story, it wouldn't have comments. Yeah. I wonder if the posts, they might just be feed posts. Each of the statements is provably false. First, it is standard medical practice for a patient to undress for examination and marking prior to surgery, as well as for maintenance of a sterile environment of same. Doctors must have the ability to examine the area that is relevant to the surgery. Second, part of plastic surgery consult involves just that, a consultation whereby the physician examines the body and provides an opinion on possible procedures. It is the patient's prerogative if they elect to go on with the procedure. Third, Dr. Mallory did not grope or parade Johnson in the nude. If a patient, and I can see the objection to the word grope because it implies something more nefarious, but we will, again, it can also imply opinion, can't it? What is for one is not for the other. It depends on how, well, we'll get to the responses to this. If a patient is seen by a relevant third party, that is following the patient's prior consent. Fourth, Mallory could not have possibly tried to upsell additional surgeries before surgery because the scope, plan, and surgical procedure for each patient is finalized on a different day and not altered the date of surgery. Johnson was given multiple sterile pieces, and the sanitary and sterile nature of the treatment provided is evidenced by the fact that she had no complications and was healing without issue or infection. But she felt that it wasn't, and some of these are opinion. To make sure each of her followers knew exactly the plastic surgeon was Dr. Mallory, Johnson commented on her own post to direct people to her Yelp statement, stating, "I have left a review under my doctor's name on Yelp. My review includes photos." She further said this doctor uses 2 different names. One is a nickname, the Dr. Laguna. The other is a name of his plastic cosmetic practice. From that moment forward, Chalene Johnson plastic surgery Yelp became a Google search term. So I imagine they're probably using Google Trends. With one of the first results being a Reddit page referencing the podcast and Dr. Mallory, but she didn't post that. Johnson then continued to incite negative attacks online, further engaging with her followers and publicly commenting, "You can put him on blast. I can't. You should." I mean, all right. I would need to see the context of all of that. Because if the context is, I've already left a Yelp review. If you've been a patient of his, you can put him on blast. Context matters. Without context, it's hard to say, but without context, just calling anyone to leave false negative reviews could be a problem. But if that's not the context, then that's not the context. The very next day, on August 16th, defendants released a third podcast episode titled Plastic Surgery Nightmare Volume 3, where Johnson continued to repeat and ratify her earlier defamatory statements. On September 25th, she took to her Instagram account yet again, this time posting photos of what appear to be a partial Excel spreadsheet. As can be seen in the below screenshots, these range from his registrations of his business to traffic infraction to small claims matters. In the midst, though, are multiple references to medical malpractice, as well as a reference to patient surgery accident and patient death. These posts also state, do you agree that it should be a patient's right to know how many medical malpractice and arbitration cases a surgeon has before going under the knife? Um, I know just from listening to Shalene's content that some of the context around this is the fact that in California, you can have arbitration clauses in agreements for surgery. And if there is an arbitration clause, even if someone files a malpractice suit, it will go to arbitration. And if it resolves, it'll just get yeeted out of court. It will not be a public record per se. And that is why there are arbitrations for doctors, because doctors do get sued. But that's part of this conversation is, well, if doctors are constantly going to arbitration, should you know, which harkens me back to like the Girardi stuff, should you know about the lawsuits and how would the public know? So, um, Johnson intentionally or recklessly disregarded the fact that each of these medical malpractice notations were lawsuit allegations that were either defeated by defense verdict or voluntarily dismissed by the plaintiff. The thing is, with voluntary dismissals, though, that can be per settlement. And a voluntary dismissal by a settlement doesn't mean it didn't happen, it means that it's resolved. So these are the photos. Indeed, in two of them, Malavi was not even served, so his involvement was peripheral at best. I mean, how do you know? I guess the dates, maybe he's connecting these things to say, I wasn't involved in those. Yet any reasonable viewer would infer from the Instagram post that Malavi had committed medical malpractice multiple times. I I mean, I get why they're arguing that. They're asking, should a surgeon know? But also, I mean, I can see their argument, but I can also see the argument of um this is a compiling, this is a research document, this is not a statement of fact. This is again just a photo of research being done. So I can see it both ways. I understand why he doesn't like it. And he was responsible for a patient surgery accident and patient surgery death. We'll get to the patient surgery death because in the responses that we will get to, that filing by the medical board is attached to those responses. Each of these things are patently false. There have been 0 cases where Dr. Malavi has been found to have committed malpractice. But again, 2 things can be true. If you settle, then the case doesn't continue to go forward. And if there's an arbitration clause, it goes to arbitration and settles. So that's the crux of what's true. And when you come down to it, if multiple medical malpractice cases have settled, will a jury say, okay, well, you this doesn't imply that you committed medical malpractice. This implies that you were sued for medical malpractice. And if you were sued, then isn't it substantially true that you were sued for malpractice, even if it resolved? So getting into this part, if it goes to jury, it will come down to, right, but if you've been sued for it, does that make it false? Because being sued for malpractice and that suit being found by a jury are 2 different things. They say Malavi has also never been found responsible for any patient death or have engaged in patient surgery accident. And again, we will talk about the patient death because the stuff from the state is attached. How they define responsible will be interesting. So, very, very interesting. Let's see. Let's see. Where did we go? All right. A few days later, on or about September 29th, Johnson began an online posting tirade, they say, where she posted on her Instagram account yet again with Dr. Malavi multiple times. It's interesting. Again, lawsuits or allegations and shade, stating with a video teasing that she has uncovered the sexual misconduct, corruption, and medical malpractice and patient death at the hands of her plastic surgeon, and that victims are coming forward pleading to her 703,000 followers to repost and share the earlier posts. Again, we will get into the facts of the thing as we get into the thing, because her responses included quite a lot of signed declarations. So again, if people have shared their experiences, things can be true and still unflattering. Um, she then continued posting a series of Instagram story posts to falsely allege that a patient died on Dr. Mawabi's table. We will get to that attachment, and you can decide if that statement categorizes it accurately or not. But again, we will see. The one that is attached is a patient who passed after surgery. So, of course, Dr. Mawabi has never been responsible for any sexual misconduct, corruption, or medical malpractice or patient death. Responsible is an interesting word. If these have settled, and there's an attached lawsuit that did settle for $1 million regarding a patient death, what does responsible mean? Like, if you settle a case, is that responsibility? I don't know if a jury would be empathetic to being like, right, but all those cases resolved for financial payouts. If that's the case, if a jury would say, oh, well, then clearly you didn't commit malpractice, or have, even though you've been sued for malpractice. Does saying someone's been sued for something say that they've done the thing? And that's, we will get into it. They go on to talk about a September 29th Instagram tirade continued with clips of her and two other women's postoperative scars, where she conveys that the other women developed infections because of Dr. Malavi. Again, there are, in the responses that we will get to next, there are photos and there are signed under penalty of perjury's declarations involved. And again, if those people testify that that was their experience, then that is a defense. That is not untrue if that was their experience. She promised a certain size scar, but woke up to something much larger. Not only is this untrue, again, Chalene included a declaration from her doctor, so we'll get to that. They say not only is this untrue, but it is directly contrary to Johnson's earlier statements, where she raved on multiple occasions that she is happy with her results. I think raved is an interesting characterization of, I don't have issues with my results, but okay. But that also is not, I understand they're trying to, it is their complaint. So they are going to use the light most negative to the defendant. That is what a complaint does. So they're going to be like, look, lying then, lying now. And that's what they're trying to insinuate. Perhaps most egregious was that in the last two posts during a September 29th Instagram tirade, and again on days after, she proceeded for the first time to claim sexual misconduct by Malavi and trauma therefrom, and requested that other victims text her with a number provided. The vague accusations of trauma from sexual misconduct lead any reasonable viewer or reader to believe that Malavi is a sexual assaulter, who took advantage of his patient. Again, context matters when it comes to defamation suits. Like her other posts, this too is not only contradictory of her prior statements, but also patently false. Malavi conducted himself in a professional and appropriate manner, as evidenced by signed declarations under penalty of perjury from the operating nurse, general surgeon, and physician's assistant who were part of Johnson's surgical team and interacted with Malavi and Johnson. In September 29th tirade post caption, Johnson encourages others not only to write Yelp, Google, and real self reviews, but also to continue sharing her post to spread her defamatory conduct far and wide, i.e., the post which she monetizes on her platform. They are obsessed with the monetization. Dr. Mawabi's Yelp and Google pages have since been spammed by random third parties, leaving one-star reviews despite never having been a patient, which is not okay, but also in context asking, hey, if you've been a patient, leave a honest review, again, like the H3 case, is different than people leaving fake reviews. Fake reviews, never okay. But it'd be interesting if they cited directly to where that was encouraged. I'll have to go look at the September 29th Instagram for context. Not fully satisfied with her level of damage, they say. Johnson took to her Instagram account on September 30th, stating, "I am outraged that a surgeon can lose their privileges at multiple hospitals. Patient death, have dozens of medical mal cases, 210 hidden Yelp reviews, and the medical board allows this. It's deception, and plastic surgeons are protected by a very powerful group of lobbyists. This too was false, as Dr. Malavi has not lost, quote, privileges in any hospital, has not been found responsible for any patient death, and has not had dozens of medical malpractice cases." And again, cases are lawsuits. If lawsuits have been brought, even if they resolve. So parsing words is going to what a lot of this comes down to. Nor is he inappropriately hidden 210 Yelp reviews. And then it's a picture of the post. Despite its volume, the tirade did not end there. In a podcast episode on or about October 1st, titled Breaking My Silence, defendants explicitly named Dr. Malavi and proceed to make this is at or after the original suit was filed. Hold on. I need to know the date. She needs to know the date of when the first suit was filed, because otherwise I can't move on with my life. Let me pull that up real quick. I don't want to leave the fact, but I need to pull the original one to see the date it was filed, because I believe those are close in time, and I am just curious to see the dates. I need to know the things. Let's see. Where is this one? We are tracking too many cases. This was filed on October 14th, 2021, the original suit. So this was filed close in time. I just couldn't remember the exact timing and was curious. So this is the October 1st, title Breaking My Silence. Defendants explicitly name the doctor and proceed to make following non-exclusive false and defamatory statements. That Dr. Malavi created a HIPAA violation by addressing me by my full name and sharing some of the details of my treatment. I wonder if that's regarding his response on the Yelp review. I think that it is. Implied that he committed sexually inappropriate acts while Johnson was on the operating table, stating that her vagina was sore after surgery, that Dr. Malavi's anesthesiologist has 2 DUIs, that Dr. Malavi, while operating on a woman, allowed 2 of his surgical techs to perform surgery. And in doing so, these 2, unlicensed professionals, if you want to call them that, created deadly punctures to her organs, which resulted in her basically going into cardiac arrest and not on the table. They sent her home. She didn't know she was bleeding out. They sent her home, and that night she ended up going home, collapsing, being rushed to the ER. And for that patient's death, he created a lot of problems with that woman, not just her death, but he failed to report in a timely fashion, not to mention, this is all a quote, not to mention the fact that it wasn't him performing the procedures. There were countless other violations. Unfortunately, she passed away. That is attached. So that statement is coming from something that's attached in her response. So we will go through it. They don't address that in this because they haven't responded in public record to the responses that she has filed. So I don't know what happened in the OR. Based on what the Attorney General records have indicated, it's possible that somebody else on his staff who was not trained did some or part or even the majority of my surgeries. That's stating I don't know, but speculation. So not stating it as a fact. Stating her procedure was not a mini tuck. I didn't ask for that. I wasn't told I was going to get that. That's not the standard of care. There's a declaration attached that addresses that. How ridiculous it is that if a patient dies at the hands of a doctor and that doctor is not required to disclose to you. That's just, again, that's a statement of not about Dr. Malavi. I think that's a statement on the nature of the law and requirements in California. I don't read that as a statement against that doctor. But you let me know what you think. But don't you think it's pretty important to know that your anesthesiologist has 2 DUIs? Again, the anesthesiologist isn't suing. So I don't know if those statements are defamatory to Dr. Malavi. And again, that's a factual thing that would be easy to determine. Johnson admits on the October 1st podcast that she had over 1,800 people in this Facebook group digging through records about Malavi. Okay, there's a Facebook group. I guess that goes to the harassment though. So That's, I guess, what they're including that for. The October 1st podcast posts are false. What defendants intentionally and recklessly omit in the October 1st podcast with respect to a third podcast post, I'm assuming that's from Facebook, with respect to the third party death, is that these are all unproven allegations and that Dr. Malavi has not been found liable for any of these acts. Okay, so they're saying these are allegations. Yet defendants state them as fact to deceive an audience of thousands of people who will reasonably infer that the investigation conducted by defendants and her followers has rendered these results factual. Okay. In the context of prior postings on the October 1st podcast as a whole, the October 1st podcast post further falsely and damagingly implied that Malavi committed sexual misconduct while Johnson was being operated and that he did not personally conduct the surgeries. I don't know if she stated that as fact. I think she opined or questioned, but okay. Defendant's statement in the October 1st podcast post that Dr. Malavi committed HIPAA violations is likewise false. Malavi did not use Johnson's full name on Yelp or reveal private patient information. Johnson had already revealed herself in the Yelp review, identifying and directing people to her podcast, and also publicly directing 700,000+ followers on social media platforms to go on Yelp to read her review. The next day, on October 2nd, apparently still unsatisfied with the amount of damage she had already caused, and after specifically identifying Malavi as her target, or as her surgeon, Johnson posted on Instagram yet again, this time falsely stating in a video, "After my botched surgery, I learned that he has done this to thousands of women, i.e. grabbed both of my breasts with his bare hands and told me he wanted to make me hot." Again, if that we're going with, she's saying that this is what happened, would someone categorize that as groped? That's her experience of what happened as she is saying it. How would you categorize that? So, okay. That a patient died on his table resulting from allowing his surgical techs to do the procedures. And I can understand if this is regarding the same patient where they have issue with, well, somebody didn't die on the table. That's a factual difference. Will that be a difference that matters? We'll see. And that his anesthesiologist has 2 DUIs. Again, the anesthesiologist isn't suing. I wonder if they're trying to imply that this somehow damages his reputation by saying he'd allow an anesthesiologist that has DUIs in the past to practice. The underlying caption in the post states, "Can someone please forward this to the California Medical Board and California Attorney General? I have some very eager witnesses who would like to speak with you. Broke my silence today on my podcast, including naming him and the investigation results of the patient death. Collectively, the October 2nd Instagram post, clips of which are screenshotted below." So those are screenshotted. Those look like reels based on the little reels icons, but post reels, fair. The statements on October 2nd were patently false and misleading, communicating to any reasonable reader or viewer that he had inappropriately grabbed Johnson and hundreds of patients, which is not true, and that a patient died on his table resulting from technicians performing procedures, which is also not true. Moreover, the anesthesiologist who participated in Johnson's surgery did not have 2 DUIs, quote unquote. All right. To reaffirm and ratify the falsities she had previously spread about the doctor, on October 11th, Johnson released a series of posts on her Instagram titled PSA, Shocking Facts I Uncovered About My Plastic Surgeon After the Fact. These series of posts each have a heading titled Dr. Malavi, aka Dr. Laguna, to clearly identify her target or her doctor, and falsely state that Malavi, among other things, quote, "In 2018, he allowed unlicensed medical professionals to carelessly perform liposuction on a woman, which resulted in her death." And this might be the parsing of words. We will get to the reply that's filed, because this might be the difference between saying it's alleged that in this filing in 2018, he allowed this. And that might parse the difference, because in defamation, the difference between saying these are allegations and these are facts is different. However, there is also a lawsuit regarding this particular incident that was settled for $1 million. So we will absolutely be going through the responses. I know we're like 2 hours and 13 minutes in. Chat, be the law nerdy awesomeness that you are, and hang with me because I know that the mods are doing their work. So we are going to continue to go through this, but there when we get to the differences with distinction, again, if it's proved to be true, then it's proved to be true. If it's just been alleged, then it's just been alleged, and that difference might matter to them, which is where you work with lawyers on sharing things. The thing is, it might not matter to a jury. A jury might be like, it's substantially the same thing, but we'll continue on and we'll go through the response. Just moments before surgery, while women are naked, nervous, and vulnerable, he regularly degrades and intimidates them into additional surgeries. Again, there are a lot of declarations that are attached to her response. They say that past complications, infections, and patient death have resulted in him losing privileges at several hospitals. I would just imagine, because it's such a specific claim, I would imagine that there is something to back that up, but we will see. What else? He regularly leaves in the middle of surgery to consult with new patients. He uses threats, intimidations, and lawsuits to silence those who have the right. It's interesting what they drop off because context does matter. Shared a photo of her bandaged scar, claims that this was supposed to be a C-section revision, despite previously publicly declaring she had a mini tuck. I mean, it's nitpicky at that point, but if her expectation was, well, we'll get into the declarations. And then they shared the different social media posts. The October 11th Instagram posts are false, misleading, and further target Mallory in a damaging manner to Johnson's thousands of followers. Defendant's defamatory conduct escalates in dangerous harassment. They talk about in numerous Instagram posts, including on October 13th, Johnson began tagging Mallory as hashtag Dr. Laguna, which is his Instagram name, and hashtag Dr. Mallory simultaneously with promoting her postings and her podcast, which directly identifies Mallory, alerts her followers to his personal social page. Is it a personal social page? Hold on. I take issue. I am distracted. We're just going to Instagram real quick because it's just been my impression as I've gone through reading this case that he is also a social media personality. So let me look real quick because I am. Oh, that doesn't seem to be the right one. That is a different one. Let's see. I don't know if I've ever looked at his social. Dr. Laguna plastic surgery. No. I do not see one that's coming up. Let's see, under last name. I'm just curious. This is what happens when you get curious midstream, is that you start looking for things and then can't find them. I will have to come back to this because I'm wondering if he has 100,000 followers on his social, then how do you say it's a private page? Because his social media profiles that I have seen, and I don't remember where it was, have like pictures of surgery and stuff. So, yeah, no. All right, I will go find it. I don't think it is a private social media page, but we'll get there, I'm sure. I took issue with the languaging of personal social pages because I believe he uses it for work, but I will go find it later because we're already at 2 hours and 20 minutes. And directs viewers to his page and his followers. It's at Dr. Laguna. All right, look, it's linked. We're gonna go find it. Yeah, Dr. Let's see if it pulls up. Yep, it did that time. Did I do it wrong? Oh, I put a period in there. This is a surgeon's page. There are bodies. There are bodies. Dr. Laguna, name, office number, bit.ly link, not 100,000 followers, 80,000 followers. This doesn't seem like a personal social media page. This looks like a business page for a plastic surgeon. before and afters, body lift rejuvenation, ultimate BBL revisions. This looks like a linked as a plastic surgeon, linked with professional credentials. This does not look as a personal page. That appears to be a business page. Just saying. I took issue. I could not move on. I needed the questions answered. I needed them answered. That looks like a business page to me. On October 14th, Johnson extracted a photograph of Dr. Mallory from his personal Instagram page. I think it's a public page. Y'all tell me if the word personal makes sense to you, because it doesn't make sense to me. Just saying. Posted on her page, presumably to taunt him, so opinion, criticizing how he moves his hands in a video. Johnson followed up with not only naming him, but tagging, but also addressing him directly with attacks and threats, stating, among other things, "Are you trying to hide infections, sexual misconduct, horrific results?" Followed by @Dr. Laguna. All these past employees you mistreated, they are so happy to finally share what they witnessed. Many of his posts have been taken down. Why, Dr. Laguna? What are you trying to hide? Later that day, Johnson posted on Instagram saying, speaking about her religious connection. Is it a connection? Okay. Again, I'm trying to not be nitpicky with the words. It's just an interesting way to categorize that, saying, "Sir, God has asked me to stop harassing you." No. Where did harassing come from? I don't know where that word came from. In my mind, "Sir, God has asked me to stop you, and I will. You have met your match. I have made it my mission to stop your reign of evil." I mean, again, not defamatory, but they're also stating that there's a harassment claim here. So that's where some of this is going. That's where some of this is going towards. Johnson did not end there. Later that day, she posted another photo of Dr. Mallory with an arrow and captioned his name, identifying his face. This photo shown below included 3 other private individuals from his medical staff who remain anonymous up until this point. And they might have been anonymous and might not be public figures. That might be the case. Though they are not named, they name him. And then they say his unlicensed medical tech, whom OR nurses tell me he allows to do many of the procedures. His anesthesiologist with 2 DUIs. Now, that person is not the person subject to this suit. And if that's not true, if they choose to, then they choose to. We'll see. If it is true, they might not bother. The very next day, October 15th, Johnson posted a photograph of Mallory's Cosmetic Surgery Institute office location. Excuse me. Which identifies its building and business address, presumably to direct her 705,000 followers to the location. Okay. She then began tagging the pages and news outlets, the LA Times, the OC Register, Wandering Media, asking for her contacts to publications to do this story justice. I guess that because they've added the harassment claim, I understand why they're adding this in. I get it. For the next several days, Johnson proceeded to share more than 10 more postings of alleged stories she heard from, quote, victims concerning Dr. Mallory. And again, there are lots of declarations attached to her response. So if that is the case, then that's the case. So on information and belief, Johnson posted these alleged third-party accounts. Oh, wait, there's an allegation of third-party accounts. Several of which contain false and horrific allegations and graphic images of post-surgery bodies she claimed were the result of Dr. Mallory. On information and belief, Johnson posted these alleged third-party accounts. Oh, accounts, stories, not accounts, social media accounts. I misread that. To create and incite anger and rage in her audience. I guess that's one way to take it if you're the one suing. As people began to believe the third-party accounts were actual facts rather than unproven allegations and unverified stories. I mean, if they are verified, though, they are verified, though. To eliminate any possibility that a viewer could even consider her postings as unverified, Johnson proceeded to explain to her viewers that Malavi silenced victims by demanding arbitration. I mean, if there's an arbitration clause, he can do that, or paying them off to settle and demanding NDAs. Also, NDAs are common a common practice in settlements. I mean, I haven't seen a settlement without an NDA, so that does happen. And a lot of people choose to not go this fight. Chalene is like, no, I'm speaking my experience and I will fight. Others, and there's no shade to people who choose to settle. If you choose to settle, then you absolutely sign an NDA because of the settlement. If you're shocked by these stories, please do your part to bring awareness. Tell your followers to check these stories out before they expire. I have lots more to say about this. She followed with, I will continue to follow God's plan. Okay. Johnson continued with more false statements, including that Dr. Why can't we say it anymore? Dr. Laguna has a history of suing people to silence them and once grabbed the tube that a patient was intubated with and yanked it out like a sword. This means the patient could die. The doctor storms off. The October 21st post. There's actually because we're not going to get through all the declarations. There's a declaration from somebody in the OR about an incident where that happens. Of course, neither of these statements are true. Okay. The Yelp statements on August 13th, Instagram stories, September 25th. Okay. All of the posts, they are lumping together as defamatory statements. We're on page 20. On or about October 20th, Johnson posted an Instagram yet again, telling her followers that she was going to make a sign and stand in Times Square and then let them vote. That, I believe, is still on her Instagram. And the sign said, stop allowing doctors to hide patient deaths and malpractice cases. I mean, okay. Of course, any reasonable viewer or reader would understand that each of her opinions or each of her options stated facts about Dr. Malavi when in fact each is factually inaccurate. Malavi never killed anyone, never received 2 DUIs. I mean, I don't think she ever said he did. California allows doctors to continue to practice even after 2 DUIs. I don't think she's ever alleged that against him, but okay. Nevertheless, Johnson led her viewers to believe these allegations and did, in fact, stand in the streets the following day with a sign and documented on her Instagram. In her Instagram post, she pleaded for her audience, help me bring awareness if this moves you to take take action. She ended with, his name is Dr. Malavi, Dr. Laguna, and yes, he's threatening me for speaking out. And no, I am not deterred. And then he sued her. And now here we are. The next day, Malavi's call center at the Plastic Surgery Institute received a death threat, which again is never okay. Let Dr. Malavi know when he leaves today, he's going to get shot in the head. That's not okay. But the police can prosecute the person who made the death threat. And by the way, none of this that I've seen has incited threats, even though that is part of their claim of harassment and intentional infliction of emotional distress. So this was the first time Malavi ever received a death threat. Since receipt of the death threat, Malavi and his entire family have experienced fear and emotional distress, and they are claiming IIED, which is why this is brought up. But they can go after that person. Moreover, they have had to get the authorities involved. Over the next several days and a week, the harassment continued, and this goes into a slew of hate mail from multiple sources. These are not being alleged against her, and this is very similar to what's going on in the H3 lawsuit. Threats like, you don't deserve to be alive, I can't wait until you get what's coming to you, you're a predator, you deserve to be in jail, karma is coming for you, you're a pig, murderer, rotten hell, you piece of shit, you'll get what's coming to you, shame on you, you should get your license taken away, you're a disgusting person, can't wait till you lose your practice. I mean, some of those are threats, some of them are opinions. Are you the same Dr. Laguna that kills and sexually assaults his patients, according to Chalene Johnson? I wonder what the rest of the context is on that, because there's ellipses. Prior to defendant's defamation campaign, Malavi never received such threats or messages. Again, proving that was incited is hard, but I think this is them trying to not only persuade the court that an injunction is needed, but also trying to say, look, this is part of the IIED. I think that's why they've included all of that. But Dr. Malavi also received multiple 1-star reviews from third parties who were not even patients. And that, again, is something that they can address with the platform. Telling the public to beware, this is a dangerous man. Stop allowing this doctor to practice with all the deaths and malpractice on his resume. And please listen to the Chalene Johnson podcast. But again, if she's not encouraging people to make false reviews, then have the platform say these were never patients and take them down. During the same time period, this is which the reviews part is very similar to what's going on in the H3 suit. During this time period, Johnson began to insert Malavi's wife into the narrative as well, claiming no one ever stopped this man, and the people who worked for him never went to the authorities because his wife is an attorney and they all feared legal ramifications. Johnson continued her attacks on Malavi's wife with subsequent posts stating things like, "No wonder wifey went to law school, #job security. After he started his medical practice, she eventually became an attorney. Convenient, she works for him. I assume she's very busy." Immediately following these taunting posts, Malavi's wife became the target of attacks through multiple calls and messages from unknown third parties berating her about her marriage and alleged conduct as an alleged accomplice to falsify crimes. The intimidating and harassing conduct resulted in fear, anguish, anxiety, but she's also not suing. And substantial emotional distress to Malavi's wife, his entire family, and they now fear the safety and that of their young children. Again, she's not in this. But I think again they are bringing this up for damages as to the harassment towards the restraining order and towards the IIED. But okay. On or about October 26th, the new unauthorized Instagram account named actor at Dr. Malavi Results, the unauthorized account was created, which began posting multiple unauthorized photos and videos of Dr. Malavi, doubling down, reaffirming, and republishing several of the defamatory statements and accusations made by defendants. The unauthorized account began including videos of Dr. Malavi's wife and identifying her by name. She had otherwise only remained private. So even after these posts, they are saying that she remained private and was just wife. The unauthorized account also began including videos of the wife, identifying her by name when she had otherwise remained private. Johnson began promoting the unauthorized account from her own page on the date of its creation. On information and belief, the unauthorized account is run by defendants or those acting in concert with defendants. But okay, how are they if they have proof of that, that will be problematic. I just don't know if they have proof of that. It seems like a lot to believe that someone who has their own platform would make fake accounts. It seems like a reach. The promoting of another account could be problematic, but again, if it's copyright infringement and things, it should go to the platform. And if it's identifying private individuals or doxing private individuals, then that should go to the authorities. But who owns the account? They're speculating. Again, this will go to discovery, but they're speculating. So we'll see. They say, unfortunately, Johnson's attacks did not just end with Malavi and his wife. On October 27th, Johnson posted on her Instagram again, this time threatening that those members of Malavi's staff who cooperate with her are being protected, while those that do not may go to jail. Will be, I wonder what the exact language is, will be implicated and should do the right thing before it's too late. Johnson directed her message to one of Malavi's staff members who was watching her video and wrote, "I know you're watching and you have a daughter." I could see why somebody would not appreciate that statement. I can get it. But also, it's not defamatory. On her next and it's not the individual suing, but this is all going to the fact that they are asking for a permanent restraining order. On her next post, she revealed the picture of the private employee's face, stating, "Send me a text. I know you're watching." See below with the face of the employee redacted. But if that's a social media handle, is it private? So that's a question, because on Instagram, you can see who's watching in there. So yeah, send me a text. I know you're watching, but this is the screenshot of it. And these are different screenshots. and I'm looking at the screenshot because I wanted to see the context. Have past staff/nurses come forward? Will they go to jail? Many have, and they are being protected. They have been instrumental in the investigation, and there are declarations attached to her response. There are others who have knowledge and must not realize that they will be implicated. If they are smart or has an ounce of morality, they will do the right thing before it's too late. I know, ooh, excuse me. I know you're watching and you have a daughter. Do the right thing. Text me. I will help you. The truth will set you free. I don't know if those two things are connected and how close in time those are connected. So, again, they're going to characterize things the way they do, but we will see. We generally just leave kids out of it, but I don't know who this is directed at. And there's no way to know how connected these two things are in time because, again, we don't know how close these two things are in time. But again, allegations. On October 27th, defendant's course of and they're, again, when they file the complaint, they're going to take everything in the light most negative to defendant and most favorable to them. And then the opposite will go back the other way. But what is said in these two posts is not exactly what's recited. Indeed, on September 30th, Johnson posted on Instagram that she is obsessed with Dr. Malavi's practice of medicine. But by October 27th, she had posted yet again another spreadsheet with all sorts of alleged information about Malavi, saying, I know everything about this man. And then they texted the thing. Curious, do we know where he went to medical school residency? I know everything about this man, and showing a list. Okay. On information and belief, Johnson's course of conduct referenced above, including defamatory statements, served no legitimate purpose, was instead made willfully and directly to intimidate, annoy, harass. This all goes to their claims of IIED and civil harassment. His staff, his family, and cause them severe emotional distress with the expectation, intent, and belief that her thousands of followers would be incited to then retaliate, harass, and threaten. I don't know if that's inciting. Plaintiffs believe that unless immediately stopped, Johnson will continue her harassing tirades. On information and belief, and they talk about the defamatory statements made to a large audience. They talk about the false light. So this just goes through, again, taking everything above and consolidating it into the claims, which is actually well written and concisely done. Once we get to the end of their perception of the case, or their allegations of the case, we get to this is the false light, that's the defamation. In addition to the defamatory statements, Johnson has actively pursued and sought communication with several potential and current patients by disseminating defamatory statements to them with the intent of dissuading them from retaining or maintaining Dr. Malavi's medical treatment or care. So that would go to the interference with economic relationships claim. Since defendant's defamatory statements, the practice has been damaged, with both consultations and surgeries decreasing considerably, the amount of which will be proven at trial. And that's kind of typical, the amount of which will be proven at trial. And they allege the defamatory statements and ongoing harassment has suffered intense and severe emotional distress, being subject to other things: shame, ridicule, threats, online attack, humiliation, and anguish. On information and belief, and then they restate that her Instagram following has increased, again trying to show that there is incentive to do it. I guess first cause of action, defamation, it restates what's above. Second cause of action, false light, which is, again, casting someone in a false light that's reputationally damaging. So similar to defamation, but slightly different. Again, he's going to be a public figure in all of this. But again, truth is a defense to defamation. But again, it's more than just the defamation claims here, because you've got the intentional infliction of emotional distress. So he has suffered distress. I don't know why they didn't also plead negligent infliction, which is odd. But that's all. The continued posting on social is what they're saying, and that was with reckless disregard for his health and well-being. I mean, we'll go through the response as I evaluate that. Interference with prospective economic advantage, and they actually showed more clear, I would need to go through the law on this again, but a more clear connection than they did in the H3 suit for sure. They said, look, there were patients, those patients canceled, and this is why they canceled. If they can prove that, then they might have interference with prospective economic advantage, but not if things are true, because you need the false light in there too. So, not if it's true is going to be the thing, but it is more clearly pled than any other cause of action we've seen there. And then the harassment and violation of California Civil Code, which they are saying that the social media conduct conducts harassment. And let's see, on information and belief, defendants in each of them have engaged in recurring and unwanted conduct on social media. And they talked about the intent is to terrorize and harass, create a false narrative, and end his career while giving defendants the benefit of additional social media following for their monetized accounts. That reiterates what's above. Prayer for relief is actual and compensatory damages, not less than $1 million. Punitive damages are the punishment ones, permanent injunction. And that's where a lot of this goes to, is the permanent injunction. As to the third and fourth causes of action for intention for the IIED, they're asking for damages, compensatory and punitive. Fifth cause of action, asking for a permanent injunction, and then also filed a civil harassment restraining order. We are going to go over to some of the response to that now, because mods, thank you for hanging in there, because I know we are at like 2 hours and 40 minutes. Chalene has responded to the lawsuit in the form of an answer. The answer was filed on November 10th. It is a form answer. That is just what it is. It's a form answer. General denial of all the things, and then assertion of defenses. First, affirmative defense, barred by California's civil code because it's free speech. Failure to state a claim, true or substantially true, no provably false assertions of fact. Not concerning plaintiffs, not defamatory because it's true, immunity from internet republication of defamatory material. So it's kind of the reporting privilege under California. You can accurately report things. Lack of knowledge or intent, lack of negligence, lack of intent, lack of proximate cause, failure to plead special damages, constitutional right of free speech, lack of actual malice to the defamation, because he is a public figure. And I think he is at least a limited purpose public figure as it relates to his surgeries. Presumed punitive damages disallowed, mitigation, contributory conduct, avoidable damages, lack of damages. So these are all these standard defenses that you're getting into. And then we get to the responses to the civil harassment restraining order. One of those responses being an anti-slap motion, saying that the restraining order is an illegal prior restraint on free speech. We will get into that real quick. We talk a lot on this channel about slap and anti-slap motions, because a slap lawsuit, strategic lawsuit, or strategic litigation against public participation is trying to improperly shut someone the fuck up. And the anti-slap is saying, no, I have a right to speak. You cannot do the thing. So that is what the response is. And this is in regard to the civil harassment restraining order. So this is not a slap filed against the lawsuit. This is an anti-slap filed against the motion for restraining order. So those are two separate cases, really. I should back up. Mallory filed a notice of related case on, November 15th. So this notice of related case was filed November 15th, sharing that there was a related case filed, and that's the case for the civil harassment restraining order. So it's, hey, I filed the lawsuit for defamation and then subsequently filed the civil harassment restraining order. They are two separate cases. So we've seen the lawsuit and the legal response to the lawsuit, the legal response being these are general denials and these are our answers. And then what is heading towards court more recently is the civil harassment restraining order. And that's wherein you get the anti-slap motion and response from Chalene's team. So that is what we will be going over now. We're not going to go over the motion to quash today. There is also a motion to quash, a deposition notice filed as well. But that we will leave for another day. So again, this is a response. I say it in every defamation suit. When you are engaged in a lawsuit, it is always better to just take the advice of the Pop Brothers and often me and shut the fuck up. However, when you have lawyers that you can run things by, I can understand why Chalene is like, the point of his lawsuit is to make me shut the fuck up. So therefore, I will not, in fact, shut the fuck up. Always difficult when you are in litigation because everything made and everything said will be used against you. But if you are in communication with counsel, people will choose to do that. And we have seen that in the Aldi lawsuits and we have seen that in others. Always, when I say if you're in litigation, but I also get it because I've listened to the podcast and I get the response to be, well, if you would like me to stop talking and you're suing me to stop talking, and I feel like what I am saying is the truth, I have a First Amendment right to say it, then during the course of litigation, you would keep talking. It is just whether or not you have whether a person chooses to fight this fight out to the end, knowing it's going to be expensive and saying, I'm taking that head on. And you are working with attorneys and doing that. Like with Alec Baldwin in the middle of an investigation, I'm like, shush, do not talk. I can't imagine his attorney signed off on this. But based on the podcast, listening to Chalene, she has said, I've talked about this with my attorneys. I will exercise my First Amendment right. I imagine there have been substantial conversations about what that looks like. So just my general perspective on all things, but also I get it because it's like, if somebody sues you for defamation and you're like, but what I'm saying is the truth, then if you stop talking, do they get what they want? And same with like the H3 podcast. Do you get what you want if we stop talking about the allegations made? And so why would I? I get it. So that's the asterisks on the whole things. All right. Let us continue. This is the slap motion with regard to the civil harassment restraining order, and it addresses the civil harassment restraining order is based on the same operative facts that are in the complaint, and this addresses those. Defendant will move for attorney's fees and cost in the amount of $56,000. That will probably go up as this litigates. And again, on a slap motion, if you win the anti-slap motion, then the other motion, in this case, the civil harassment restraining order motion, will get thrown out with prejudice, and if the defendant wins, they will get the lawyer's fees. This is a burden shifting, and we have talked about the burden shifting in all of the other anti-slap motions that we have covered, because we have covered a lot of them because California has a very strong anti-slap statute. This action is part of an all-out attack by petitioner on respondent Chalene Johnson in an effort to silence her constitutionally protected efforts to speak out about the egregious malpractice and criminal conduct of Dr. Mallory, aka Dr. Laguna. I appreciate that they put the registered trademark symbol after his name. I don't know if it's shade or just them being thorough, but I appreciate it. A self-proclaimed world-renowned plastic surgeon and his inappropriate and egregious mistreatment of patients under his care. This request is sought a prior restraint and is Dr. Malavi's strategic method to restrict Johnson's free speech. So trying to issue a restraining order, a civil harassment restraining order to stop somebody from speaking on social media if it's protected free speech can be a prior restraint. Plaintiff Mallory and the surgery center initially filed their baseless complaint against Johnson, a motivational speaker and social media personality, for defamation and other related torts regarding Johnson's statements during her internet podcast and in social media postings. What plaintiffs sought to stifle by claiming defamation was Ms. Johnson's accurate reporting to her followers about her experiences and the experiences of others related to the malpractice, unprofessional, and criminal conduct of Dr. Mallory. Well, Johnson would not be cowed into silence and continued her podcast and postings, including discussing the petitioner had sued her. Plaintiffs filed their First Amendment complaint, which is what we just went over, to add a cause of action for harassment and to request injunctive relief. So those are the new things in that FAQ. The next day, petitioner requested a civil harassment restraining order, also in the Orange County Superior Court case number, and attached to the FAQ as an exhibit. Oh, is it? Did I see exhibits in my FAQ? Did my FAQ have exhibits? Did we not go through the whole FAQ? I did not see it. Maybe it's not, because again, this was downloaded from the court's website. I did not see it attached. It is not attached to the one that I downloaded, which might be because the court does not make that public. All right, that's not helpful, but I do not see it in the FAQ because it is not attached in the one that I downloaded. But the court would have it, so, that's what matters. Let's see. Then I lost my place. Damn it, Emily. Keep reading. Keep reading. I had to see. I had to know. I had to know if I missed it. I couldn't let it go. Couldn't let it go. This court rightfully denied Malavi's request for temporary restraining order, finding that he could not make a prima facie showing of Ms. Johnson making threats of violence or encouragement of violence by any of Ms. Johnson's followers, which is what the standard is going to be there. And again, because threats of violence came from third parties doesn't mean they were encouraged. In fact, we will get to the post where Chalene specifically says, do not make this situation worse. Do not threaten people. Let us go through the process. Let me tell my story. You support me by listening to the podcast or sharing the information, but not by making threats and harassment. And anyone engaged in these kinds of suits, I've not seen anyone who said, yes, I want my audience. Well, I can't say I've not seen anyone. Most people do not say to their audience, yes, go strike. Gosh, I can't make this bigger. Go strike people's channels, go harass people, go threaten people. Most people do not do that. And I have not seen any indication of that in this case, even though the plaintiff was trying to make fetch happen on that point. So most people do not do that. And it's terrible for their case if they do. And if they do, then they should be restrained from doing that. But again, it has to be proven. This campaign to silence Johnson is precisely the type of SLAP, strategic litigation against public participation, is intended. All of Johnson's statements are constitutionally protected speech made in a public forum about a matter of public interest. There has been no determination by any court that the statements made by Johnson were defamatory. In fact, as evidenced by the declarations from former patients, employees, and associates, the statements made by Johnson are true. Footnote. While the statements are true, even restriction of untrue speech would be unconstitutional. I appreciate the statement. The declarations attest to his crass, abusive, and unprofessional treatment of his patients. And Chalene goes over these in her podcast as well. If you want to listen to this from her perspective, you can. His repeated failures to comply with the standard of care, not at least resulting in a wrongful death action that petitioner settled for $1 million, and a pending Medical Board of California accusation charging Mallory with gross negligence, aiding and abetting the unlicensed practice of medicine, false representations, dishonesty, and corruption, and general unprofessional conduct. And that is attached as an exhibit as well. As the court correctly noted, in denying petitioner's request for ex parte temporary restraining order, Johnson has not threatened violence against petitioner, nor has she encouraged anyone else to commit violence against Dr. Mallory, nor has she maliciously defamed petitioner. Instead, she has accurately and faithfully reported true facts about a public figure as discussed the perils in researching and selecting surgeons for plastic surgery, which is a matter of public interest. California case law is clear that these are matters of clear public interest. Keep reading, Emily. Don't interject. Just keep reading. And therefore, protected speech. While Mallory wants to avoid the public condemnation and shame for his misconduct, those are not legitimate grounds to seek a restraining order against Johnson. Therefore, Johnson now brings this SLAP motion against petitioner's frivolous actions that serve no purpose other than to punish and chill activity arising out of protected activity, to wit, truthful statements in a public forum regarding matters of public interest about a public figure. Respondent's motion should be granted. Petition for the CHRO should be stricken with prejudice. Respondent should be awarded attorney's fees. And now this is her side of the allegations in her motion. Factual background. Mallory is a self-described world-renowned surgeon. Yes, we saw that in his complaint. Petitioner is well known as a plastic surgeon operating the Laguna Surgery Institute in Laguna Beach, California, and goes by the trademark name Dr. Laguna. As noted by the Medical Board of California and its accusation against him, Dr. Mallory has described himself in the book he authored, quote, high definition liposuction, as, quote, one of the top body sculptors around the world, and is, quote, well regarded as a world-renowned face, body, and breast sculptor because of his superior outcomes in transformations. It's a strange substitution. Thanks, brain. And body transformations. Petitioner has also appeared frequently in Los Angeles and Orange County news articles, appeared on local television shows, written numerous articles and papers on plastic surgery, advertises services in traditional and social media, including touting himself as world-renowned body sculptor. Declarations B and Exhibits B and C. Malavi also holds himself out as a leader in the field, describing himself as a successful author, master, mentor, and trainer. He frequently trains physicians in high-definition cosmetic surgery. Johnson's treatment with Dr. Malavi prior to COVID-19. Johnson consulted with a different plastic surgeon, Dr. Kackenmeister. I think I'm saying that right. He also has a declaration attached to either this or the other motion. There's two. In Mission Viejo, about plastic surgery procedures, she was wanting a breast reduction and a lift and a revision of her C-section scar, also known as a mini tummy tuck. Dr. Kackenmeister advised her that he did not believe she was a good candidate for a tummy tuck. Johnson did not pursue the matter further, with surgeries being halted due to COVID-19. But as the pandemic abated, Johnson revived her interest and began researching other plastic surgeons in Orange County. During her research, Johnson came across I've been talking for 3 hours and it gets harder as we go. Came across Petitioner and was impressed by the exceptional and overwhelmingly positive reviews she saw for him on a plastic surgery review site, realself.com. During the initial consultation, Malavi made inappropriate comments and touched Johnson in a manner she was not comfortable with. However, she elected to undergo surgery because of his reputation and her desire to undergo surgery during a specific period of time. On the date of surgery, Malavi continued to make inappropriate comments to Johnson and forced her to remove paper underwear despite her request to keep it on. Malavi attempted to pressure her into additional surgeries at this time as well. After surgery, Malavi brought in males into one of her lymphatic drain massage sessions to view her naked body without first obtaining her consent. Malavi's staff initially refused to provide her with new foam dressing after surgery, instead provided her with a shirt to put under the foam. Given all these issues, Johnson terminated care with Malavi and presented to Dr. Kackenmeister for her postoperative care, Exhibit D. Johnson's subsequent discovery of disturbing facts regarding Petitioner. After resolving to stop any treatment with the doctor, she spoke about her experience on her podcast and did a podcast episode about how to select a surgeon. Following the podcast, Johnson was contacted by a number of individuals who had similar experiences with Dr. Malavi. Disturbed by her experience and the experience of others, Johnson began looking into Malavi and his practice. Malavi aided and abetted in the murder of Erlanda, I hope I pronounced that right, Swarthout. Apologies if I pronounce things wrong. Shortly after Johnson's surgery with Dr. Malavi on August 25th, 2021, the Medical Board of California filed accusation against Dr. Malavi, alleging 7 counts of discipline that's attached below, including gross negligence, aiding and abetting the unlicensed practice of medicine, false representations, dishonesty and corruption, and general unprofessional conduct. Again, when I said that this will come down to saying that he's done these things versus saying that the medical board has alleged he's done these things, whether a jury will parse something so finely when these allegations are out there, we will see, because there is a difference between saying he did this versus he's alleged to have done this. But that, again, is a choice. On or about August 2nd, 2018, Erlanda, footnote 2, had a consultation with Malavi regarding surgery, recommended multiple procedures, including high-def liposuction and a mini tummy tuck. On or about August 30th, 2018, she underwent surgery at the Laguna Surgery Institute with the doctor purportedly as the operating surgeon. Malavi allowed 2 surgical techs to perform the liposuction. At footnote 3, a surgical technician is not permitted to or licensed to perform surgery or liposuction or skin tightening on patients. They are also not licensed to provide postoperative care to patients. It is a crime to aid and abet in the unlicensed practice of medicine, business, and professions code. I don't know. I need to look, and this is on my list, to look at whether there is, I think there is also a penal code section on that, but I need to look it up. I am not 100% on that. Dr. Malavi allowed 2 surgical techs to perform the liposuction. She was discharged home at approximately 8:02 p.m. on the same day, but approximately 5 hours later, she was admitted to the hospital. Tragically, on September 2nd, she passed away at the hospital from what was diagnosed as hemorrhage from surgical intervention, leading to cardiac arrest and cerebral anoxia. That is cited back to there's a lawsuit and there is a lawsuit and the medical board allegations attached. On or about May 29th, 2019, a wrongful death and survivor action was filed in Orange County, alleging that she died as a result of multiple perforations and punctures to the kidneys during liposuction. And that's attached in a declaration as well. On or about August 11th, Dr. Mallory and the Surgery Institute paid the heirs $1 million, which was presumably his malpractice insurance limits. Malawi paid the family a 7-figure settlement, even though damages in medical malpractice actions resulting in death are often restricted to $250,000 under California Civil Code 3333.2b. Such $1 million settlements are very rare in medical malpractice cases, resulting in death unless the facts are specifically egregious, as they are here, and that's from any other declaration. The declaration's from an attorney that deals in medical malpractice. Despite the avoidable death of Miss Sarthrout, and I apologize if I pronounce that wrong. I'm going to go with Miss S, so I don't pronounce it wrong and feel like an idiot for pronouncing it wrong. Dr. Malabi has continued to allow these unlicensed individuals to perform surgery. The murder of one patient did not cause Malabi to change his behavior. He continued to allow these unlicensed individuals, AJ Reyes and James Gardner, to perform surgery on patients. In fact, Mary Carr, a former sales representative for Apex Medical Corporation, took videos of Mr. Reyes performing liposuction and renuviation on a patient in January 2019, 5 months after Miss S's murder. Not only did Dr. Malabi allow unlicensed individuals to perform surgery, which is a criminal offense, he was allowing them to do it while he was out of the room. And then they're citing back to the declarations, to 2 different declarations here. Dr. Malabi has consistently committed malpractice and demonstrated a conscious disregard for the health or safety of his patients. Johnson and multiple other former Malabi Johnson and multiple other former Dr. Malabi, I think patients is meant there, presented to Dr. Kakemeister for postoperative care. Dr. Kakemeister is a physician licensed in the state of California. He is board certified by the American Board of Plastic Surgery. He's the chief of the Department of Plastic Surgery at Providence Mission Hospital. He opined that based on his experience with patients treated previously by Dr. Malabi, he has personally witnessed a pattern and practice of Malabi performing unnecessary and excessive procedures. The frequency of complications and poor results by Dr. Malabi's procedures are unacceptable and not within the standard of care, and that is submitted in a declaration. Based on the personal experience providing care and treatment of patients of Dr. Malabi, and in his medical opinion, Dr. Malabi acted with conscious disregard for the health and safety of his patients. And this is all going to say you can't issue a civil harassment restraining order. Speaking the truth is not harassment. Finally, Dr. Kakemeister, Dr. K, we're going with that too, opined that in providing plastic surgery care and treatment to subsequent patients of Dr. M, the decision to even perform procedures was not only not indicated and unnecessary, and was even contraindicated to their health and treatment. These were not patients who were morbidly obese and needed skin and fat removal. These cases all involve procedures that were excessive, non-indicated, and harmful to the patient. The patients were pressured and persuaded by Dr. Malabi to perform these procedures, even though they were not in the patient's best interest. This overselling was completely inappropriate in putting Malabi's financial interest over the patient's health and safety. Finally, Dr. K confirmed that a surgical technician is not permitted or licensed to provide postoperative care or perform surgery. And again, these are things that one would say, hey, in my brain, I know this to be true, but if you're alleging it, you need to prove it. And they are filing an anti-SLAPP motion to shift the burden. And when you file an anti-SLAPP motion and shift the burden shifts so that the plaintiff has to prove the likelihood of prevailing on the case. They have small likelihood, but a likelihood. So this motion is saying, this is all the evidence we have showing that you can't prevail. And that can be enough for the court to shift the burden and say, okay, Dr. M, prove to me that you can prevail. So, and again, I see a lot of you saying, I'm glad we're getting her side. That is why I did these two together, because we have, when you see them side by side, and we're going over 3 hours, thank you, mods, you're the real MVPs. When we do them side by side together, I find that it can be helpful to see, this is the complaint, this is the response. And more in suits that aren't like Britney, where we're so deep into it, we're just going motion by motion. I think bringing the two together can be helpful because, again, lawsuits can be filed, and lawsuits are allegations and shade. It is a adversary proceeding where the allegations made in the complaint are in the light best suited to the plaintiff, and the response is going to be in the light best suited to the defendant. That is the practice. Which is why it's hard when things are just hanging out there, which is part of why Alec Baldwin is like, I can't just leave this all dangling out there. I need to say my piece. Oh my God, my mouth is so dry. Okay, because 3 hours. Let us continue. Dr. B is outside doing yard work and waving. Multiple patients have experienced issues with Dr. Malavi. And again, this is when you get into like, oh, we got a whole bunch of declarations here. Again, they are going to respond to this. But this is a lot of declarations that they've attached because these attorneys have clearly done the work. The legal work in this has been quite good from both sides. Multiple patients have experienced issues. Johnson was contacted by multiple patients that expressed a multitude of complaints in connection with their care and treatment by Dr. Malavi. And I should say that in the initial podcast that I listened to, and you guys can go listen, they're on the Chalene Show, she didn't name the doctor, but Chalene lives in this area. So for other people that live in this area, it doesn't surprise me, and I don't find it unusual that you would get people going, oh my God, are you talking about so-and-so? Because this happened to me, this happened to a friend. So without naming him, it doesn't surprise me that others reached out to her and said, is this who you are talking about? Because at first she did not name the individual. And now we're just getting to like, everything's going to happen in public. So everything is going to happen in public. Many of them have suffered significant injuries as evidenced by the photographs contained with their declarations. There are declarations, there are photographs. I don't even know if I can show those. I think YouTube would be like, nope. But again, I will link her link to where these are available, because if you want to look, sometimes you don't need to Google the things, but if you want to know, I'm just saying yep. If you're squeamy, don't go look. Similar to Ms. Johnson's experience, Malavi also lied to TA about what her procedure would entail, and she had a very swollen vagina after surgery. Dr. Malavi performed surgery on GC, to which she expressly advised Dr. Malavi, to which she expressly advised to Dr. Malavi she did not want. I read that declaration. It was I told him this is not the surgery I want, and that surgery was performed anyway. A number of these declarations say similar things to that. Miss Lewin lost a huge portion of the skin on her back. Miss Amon suffered burns to a large portions of her abdomen from her surgery with Dr. Malavi. Procedural history. We know the procedural history. We've just gone through it. November 1st, the FAQ was filed. November 2nd, the civil harassment restraining order was filed. Argument, California's anti-SLAPP statute. We're going to zoom past the anti-SLAPP statute because we've covered it in so many cases. It's a burden shifting statute. The defendant who is sued has to show that their speech is protected and that they can say the things they're saying. Again, public forum, public participation, matter of public interest. We saw this in Ethan Klein's suit too. YouTube's a public forum. Triller's a matter of public interest. So with this, it's the same thing. Hey, I'm making protected speech in a public forum about a matter of public interest, about a public individual, and I'm showing you why I'm doing that. And then it shifts the burden to the other side now having to prove, no, but I can overcome that burden. So we're not going to go through the case law on it in specifics. They light this out. They go through the two-step process. Did we talk about Mallory being a public figure other than stating it? I don't know if we've gotten into that yet. Because I would look for that. The first step of the anti-Slapp analysis is satisfied because petitioner's claim arise from acts in furtherance of the rights of free speech. Johnson's alleged statements about petitioner were made in a public forum. Social media is public. We're not even going to go through the case law on that. Johnson's statements were in connection with an issue of public interest. It's well settled that subject matter of this discussion likewise falls squarely within the statute. Issue of public interest within the meaning of section 425.16E3 is construed broadly to mean any issue in which the public is interested. Courts have recognized that healthcare, and in particular plastic surgery, is a topic of great public interest. I also think Chalene sharing her story is a matter of public interest because she is a public individual. And I think her sharing her story with regard to someone who's been on television and has a large social media following is also a matter of public interest. And somebody asked, and it caught my eye. I don't always look at the chat while I'm in mode. Is this a malpractice suit? This is not a malpractice suit. Chalene is not suing for malpractice. Chalene talked about the doc on her podcast and social media. He sued her for defamation and all the other stuff we talked about, the harassment. She is now trying to get the civil restraining order dismissed with the anti-Slapp. She is not suing for malpractice. She is being sued for speaking out about her experience. So hopefully that helps clarify things. Let's see. And they're talking about her, the number of people, especially women, who have minimally invasive cosmetic surgery has grown exponentially over the years. So this is going into case law holding that a website postings criticizing a widely known plastic surgeon concerning nightmare results that necessitated extensive revision surgery were statements in connection with an issue of public interest because it contributed to the general debate of pros and cons of undergoing plastic surgery. So it's going to be settled that this matter is a matter of public interest. Enough of y'all reached out and said, can you cover this? That in my mind, it is very clearly a matter of public interest because y'all are the public. Y'all are interested. Law nerds unite. Petitioner cannot meet his burden under the second step to show he can prevail on the underlying claim. And they are saying that is because the activity at issue is protected. Making false statements about him, because we just went over the complaint. I'm not going to go over each of his allegations because we went over all of his allegations contemporaneous to going over this. They're going over the postings. This all goes through the declaration and the complaint and his declaration in connection with the motion for the civil harassment restraining order, which was not connected to the downloaded version of the complaint I had, or I would have gone over that as well. Johnson's conduct does not constitute harassment. Harassment includes actual violence or threats of violence, as well as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person that serves no legitimate purpose. And that is not constitutionally protected activity. And this is what they are going to lean into, is that the statements made are constitutionally protected activity because they are free speech. And then they go through the case law that talks about harassment and free speech. A Supreme Court case, Balboa Island Village Inn versus Lemon, RD and PM. They've hit on this quite a lot that's 3 cases, and then distinguished a case. Johnson has not contacted Dr. Mallory or Mrs. H. Ms. Johnson has not requested that her followers or listeners contact him. Johnson has not gone to his office since she was there for treatment, has not been to Mallory's home, does not know where he lives, does not request her followers or listeners to go to his office or home, has not approached his vehicle or requested anyone to do this, has not been to his children's school, does not know what school they attend. And they say notably absent from his filed civil harassment restraining order is evidence of the foregoing, and it is his burden to establish by clear and convincing evidence that he was subject to unlawful harassment. The court should award fees and costs if they win. That's the law, and they will award fees or costs. That's the conclusion. I'm going to go through some of the exhibits. Thank you, mods, again. Love. I am an attorney licensed to practice, attorneys of record for Chalene Johnson. Exhibit A is a true and correct copy of the medical board's accusation, and that is listed down below. B is the homepage. C is published papers. D is a transcript from the podcast episode. E is a complaint by Kevin Swarthout, who sued on behalf of the deceased. Exhibit F is a true and correct copy of the determination of good faith settlement. So they attached the $1 million settlement as Exhibit F. Exhibit G are true and correct copies of her postings to followers advising them not to contact him. So we'll look at Exhibit G. And then the amount of time spent on the motion and the billable rate at $550 an hour. Don't tell Michelle Braxton that her excellent legal work is on par with what we've seen from the $1,200 billable hours fees, because that doesn't help anybody. Exhibit A is the accusation. So this is an accusation against the doctor by the Attorney General of California. And again, is it splitting hairs in defamation to say accused versus done? Maybe, but maybe not. But again, to me, if knowing that this is out there, suing someone for saying that this exists is very interesting to me. I would love to know what you think about that. Let's go through some of what this says. Knowing that this is out there again, do you sue? I'm asking the question because I am curious. Complainant brings this accusation solely in his official capacity as executive director of the Medical Board of California Department of Consumer Affairs. On February 4th, the doctor became a board certified surgeon. Jurisdiction, law, the medical board can do the things that they are doing here. The medical board has the right to do the things. They have the authority to do the things. They say unprofessional conduct under section 2234 of the code is conduct which breaches the rules or ethical code of the medical profession, or conduct which is unbecoming a member in good standing of the profession and which demonstrates an unfitness to practice medicine. Case law. First cause for discipline, gross negligence. Respondent has subjected his physician's and surgeon's certificate to disciplinary action under sections 2227 and 2234 as defined, particularly hereafter. Respondent's Vaser liposuction practice. Respondent is a board certified plastic surgeon. At all times relevant, respondent was the solo practitioner at Laguna Surgery Institute, an outpatient surgical center located in Laguna Beach. According to respondent, and this goes through his history, training, experience, and writings that were also listed out in his lawsuit saying, these are my accolades. This is what I do. They explain Vaser liposuction as high definition liposuction involving the infusion of a solution followed by the melting of fat and then siphoning of the fat. It is, that. Prior to August 30th, 2018, respondent performed approximately 150 to 180 Vaser liposuction cases. After August 30th, respondent performed in excess of approximately 100 liposuction cases. The Vaser procedure performed at respondent's surgical facility. Surgical technicians are present to provide assistance during the procedures. There's a footnote. Surgical technicians are also referred to as surgical technologists, surgical techs, or scrub techs. Surgical technicians work in the operating room with surgeons, anesthesiologists, and nurses. Preoperatively, their tasks and duty include sterilizing the equipment in the operating room, gathering, counting, and arranging the equipment and surgical tools needed during the surgery, and preparing patients for the procedure. Intraoperatively, surgical techs keep the operating room sterile, pass surgical tools to the surgeon and the surgeon's assistant, and assist in retracting tissues from the patient. Postoperatively, their tasks and duties include counting all of the tools and instruments used during surgery, applying dressings to surgical sites, disposing of needles and gauze, maintaining a sterile environment of the operating room until the patient is brought to the recovery room. Surgical technicians must possess a high school diploma or equivalent and complete an accredited surgical technology training program, typically lasting 12 to 24 months. At least we have a definition. Surgical tech assistants during Vaser liposuction procedures, including surgical techs JG and AJR. Respondent's high definition book, and then they talk about the book. Okay, we're skipping the book. The book is not relevant to our purposes as we're reading on, but they're going through the book discussing the procedures and what the doctor has shared. Respondent's book does not include any statement that for vasor liposuction procedures performed the respondents at the respondent's surgical facility, surgical techs, including surgical techs JG and AJR, also perform liposuction on patients. Respondent's book is disseminated on his website, and then they list the book and a link to the website. Patient A, on or about August 2nd, 2018. Patient A had a consultation with respondent. We've heard some of this in the bulk of the response up above. Respondent recommended high definition liposuction, abdomen, back, and flanks, abdominoplasty, incision line revision, mini tummy tuck, and medial and lateral thigh tuck. In addition, respondent recommended a right breast. I have no idea how to pronounce that word. Don't know. With implant repositioning and fat grafting. The patient underwent surgery. Also present were Dr. E.A., the anesthesiologist, nurse R.D., registered nurse first assist, nurse N.R., and circulating registered nurse, surgical tech J.G., and surgical tech A.J.R. Multiple procedures were performed. During surgery, surgical techs J.G. and A.J.R. assisted respondent by performing liposuction on the patient. Surgical tech J.G. infused the solution, and surgical tech A.J.R. removed the fat. Patient A was discharged at 8:02 p.m. At approximately 1:06 on or about August 31st, the patient was admitted to the hospital. According to the ER, patient suffered a syncopal episode at home after complaining of shortness of breath and collapsing, was brought to the ER by ambulance and arrived unresponsive. This goes through the what happened with the part. On or about August 31st, 2018, respondent saw patient A in the intensive care unit of the hospital. The next day, on or about September 1st, respondent wrote a postoperative note documenting patient's A hospitalization and condition. Respondent noted that patient A decompressed at home following her surgery, suffering an anoxic brain injury with a devastating prognosis. On or about September 2nd, patient A passed away at the hospital. The final diagnosis was hemorrhage from surgical intervention leading to cardiac arrest. On or about September 14th, respondent submitted an outpatient surgery patient death reporting form to the board advising of patient A's death and identifying the name and location of the hospital where the patient was transferred. Respondent failed to report the transfer to the hospital to the board within 5 days of learning of the fact, which seems to be required. Respondent committed gross negligence in his care in the treatment of patient A, which included but was not limited to the following. Respondent allowed surgical techs JG and AJR to perform liposuction on patient A. And again, will this defamation suit come down to the difference between this was done and the medical board is alleging it to be done? And if it went to a jury, would that difference matter? Would the difference matter between this happened and there was a malpractice suit, $1 million settlement, and the medical board getting involved? Is that different than saying this person did the thing versus this person is alleged by the medical board to have done the thing? It's going to be splitting hairs on truth. But we saw in the Johnny Depp case where the court came down on substantially true. Could a court find this to be the basis of substantially true? Could a jury find this to be the basis of substantially true? And I think that they could, because I think when we're splitting hairs this close, it's going to be hard for this doctor to prove that the statements they're alleging that this happened are not true or are non-defamatory, because there are allegations here. So we will see what they decide. Because again, one of the statements he complained about is that a patient died on the table. Well, this patient died in the hospital, not on the table. But again, will a jury find that statement to be defamatory in light of this allegation from the medical board? I don't know. So that's when we get to the hair splitting of it, that's where we're going to get to the hair splitting of it. Aiding and abetting unlicensed practice of medicine. And this goes to the same that was mentioned above. False representation, which they talk about in paragraph 14 to 32 above. Dissemination of public communication containing false representations. They're saying that he disseminated or caused to be disseminated a public communication containing a false, misleading, or deceptive statement for the purpose of or with a likelihood of inducing or rendering of medical services as more particularly alleged. So that's going to the book saying that he does these surgeries when they are accusing him of letting someone else do the surgeries. Dishonesty or corruption is the fifth cause of action. Sixth cause of action, failure to timely report an adverse event. General unprofessional conduct is the sixth cause of action. And again, there is due process in this. The doctor will have an opportunity to respond and defend themselves. So August 25th is when that was filed. This is the website that they printed out that had, and I'm going to scroll pretty fast here. The website with the different things they made about how he talks about his before and afters and the procedures that he does. We're scrolling through the pages of the website. But again, is it public when you've written a book on the thing that you do? It'll be interesting to see if he tries to argue he's not a public figure, which I haven't seen, and I don't think we will see, because I don't know if you can. Peer-reviewed, we've seen. I wanted to get to the posts about the harassment, since this is regarding the civil harassment restraining order, and I will link the public link to this file document. So this is the wrongful death and survival action. So again, not a medical malpractice action, but a wrongful death lawsuit. And then they attached the payout for this. This is regarding the patient that the medical board's allegation regards as well. This is the settlement and the case being dismissed, showing that the settlement in one of these documents is a $1 million settlement. They also file a declaration with a lawyer who does medical malpractice, stating that $1 million settlements are rare and are generally capped at about $250,000. Let's see. I was looking for the social media posts that they had referenced. And these are the social media posts they referenced. Although he has identified himself, I strongly discourage anyone from reaching out to him, contacting him via social media, leaving negative or offensive comments, questions under his social media posts or other business related sites. The most important thing you can do in this situation is to help get the word out that this is even possible. Please help me make a change happen. Help to send the message to lawmakers and medical boards that moving at a snail's pace and sweeping things under the rug places the lives of innocent people in jeopardy. And then I've taken continued efforts to carefully leave this doctor unnamed. It has come to my attention that he has identified and addressed me by my legal name and discussed sensitive matters of my treatment on a public forum. While he has identified himself as well as violated my HIPAA rights, I wish to ensure that my involvement in this matter remain professional and factual. I discourage you from writing negative reviews on any site unless, in fact, you have a personal firsthand experience with this doctor. No one should ever threaten or attack. Do not stoop to that level. Again, the dates on these, I'm not clear of. This doesn't help me. It hurts me. The truth will speak for itself. Do not contact him, his office staff, or comment on his social. It's just not needed. Don't attack your enemies. Pray. The truth will come out. And more posts in the Facebook group. And then we get into the opinion of a lawyer who practices in this area, that this is above what they normally see, that $1 million settlement is very high. They normally see them capped at $250,000. And so when they shared opinions in the above motion, these are all of the declarations that back them up. I traveled to California to observe the doctor. This is from the person who went by their full name, who was the Apex Medical Corporation representative. I observed AJ Reyes performing vaso liposuction and rejuvenation on patients, is not a physician. I have a video of Reyes performing the surgery on the patients. Moavi had both of his fists underneath the patient while Reyes was performing the surgery. The patient was at an extreme angle. I worried she might fall off the table. Malavi was not wearing a face mask or other type of face covering during the surgeries. Below are screenshots. And so, I mean, look, if the doctor is suing for defamation over you're allowing people who aren't licensed to engage in procedures, and you have a declaration of someone saying, I witnessed this, and in fact, I have video of it, then we're going to get to, okay, but is it defamatory then? While Reyes was performing skin tightening on one of the patients, I left the operating room with the doctor while he performed a consultation. So he left the surgical field. When I returned to the operating room with the doctor, Reyes was still performing the skin tightening. There was no other surgeon in the room when I left. At the conclusion of surgery, while the patient was still under anesthesia, Dr. Moavi said, "So hot, look at that," and slapped the patient's buttocks twice. So again, truth is a defense to defamation. There is a very extensive declaration from Dr. K talking about working with both Chalene and another patient from Dr. Moavi and his impression that the procedures caused unnecessary and excessive scarring and a very poor yet sadly expected result. He talked about the large incisions and scars in an odd and unexpected place, and went on and say that there was wound issues, had to provide substantial amounts of care to that patient. He also states in this that that patient has allowed him to share. He talks about his treatment of Chalene Johnson afterwards, talked about her result, talked about another patient and her result that he had worked on after this doctor. I have personal knowledge of the medical condition and treatment of patients who have seen me after him and providing surgical care treatment to subsequent patients. The cases involved procedures that were extensive, non-indicated, and harmful to the patient. My understanding based on my own conversations with these patients is that they were pressured and persuaded to perform these procedures, even though they were not in the patient's best interest. This overselling was completely inappropriate in putting Moavi's financial interests above the patient's health and safety. Not only is it my medical opinion that he fell below the standard of care, but that it's my medical opinion that he is a danger to the community and to his plastic surgery patients. It is my medical opinion based on my experience treating patients of Dr. Malavi that Dr. Malavi has acted with deliberate indifference to the health and safety of patients. It's my medical opinion that the poor results of my patient who were previously treated by Malavi were caused by Malavi's substandard treatment as well as inappropriate overtreatment. And that goes on to talk about the touching of a patient during procedures and how that is not within the standard of care per his opinion. Talking about how he is a plastic surgeon, covers a patient. If a patient does not have concerns about their breasts, I will not ask them to remove their bra. I have never asked a patient to remove their underwear for a consultation on a tummy tuck. I might have asked a patient to slightly lower to above the pubic region. However, removal is not necessary. So again, talking about that level of quote unquote getting naked that is alleged to be defamatory. I viewed videos of Dr. Malavi performing surgery on a patient. I also viewed videos of another individual performing surgery on the opposite side of the operating table. Specifically, this individual was performing liposuction and renuviation. I was advised that this individual is not a licensed physician or licensed PA. Assuming this individual was not a licensed physician or licensed PA, it is wholly inappropriate for them to perform surgery, even under supervision. The only persons permitted to perform liposuction and renuviation are physicians. It's unethical and a breach of the standard of care. And this backs up again, or this doctor's opinion goes into what the medical board said. So this all backs up that Chalene's side of this is, her side of this is, I am speaking my truth, I am speaking my experience, and I am sharing stories that are in signed under penalty of perjury declarations, and that is permissible speech. So you can try to sue me and say that I'm doing all these things, but at the end of the day, we are going I will prove that these things are true, and therefore it's not defamatory, it's not harassing, it's not threatening. There shouldn't be a restraining order. And that's the first thing we'll see is this slap motion going forward with the civil harassment restraining order. On the resolution of that civil harassment restraining order, it will be very interesting to see what the doctor chooses to do with the civil lawsuit on defamation. So I don't know how bringing all of these into public record are going to help the doctor who has chosen to sue Chalene, but also not every patient would be in a position to hire lawyers to find past patients by sharing on social media their experience, have them sign declarations and defend their case. Not everyone would be able to do this. And not everyone would have the fortitude to do this or the money to do this, which is, I think, what Chalene has been sharing in her podcast. Hey, I have the platform and the fortitude to do this. So many people have come forward that I am sharing my story and their story, even though her surgical result was not negative, her experience was negative, and she's allowed to share that, so long as it's true. Now, whether this lawsuit will come down to splitting hairs over a patient dying on the table or a patient dying at the hospital, I don't think that would play well to a jury. I just don't. That is my opinion. This gets into somebody who shared about working in the OR. And there are numerous more declarations. I'm not going to go through all of them. Chalene goes through quite a lot of them on her last podcast episode, and a number of them contain photos. One of them is from a surgical room. This is one of the express instances of defamation, so I wanted to share this one. Registered nurse in the state of California, have been licensed since 2014, have been a surgical nurse at the operating room from mid-February 2021 till April 2021. I've worked as a surgical nurse for numerous plastic surgeons prior to working with Dr. Malawi. I was contacted through a medical staffing agency. During my time at his office, Malawi routinely say things to patients like, "What are we going to do with that ass? Don't you want to look good? You don't want your man to leave you." These statements were made while these patients were fully nude in front of multiple men. This made me uncomfortable and seemed unprofessional and inappropriate. I was in the operating room with Dr. Malawi between mid-February 2021 and April 2021. During that time, I observed, I think this is who they refer to as JG, James Gardner, and AJ Reyes, scrub technician, routinely perform liposuction and renuviation. Dr. M would regularly leave the operating room while a patient was undergoing surgery. Dr. M was out of the operating room. Gardner and Reyes would perform liposuction and renuviation on patients. I observed Gardner manage patients' postoperative pain, contact patients about their drains, and make treatment recommendations to patients, which I found unusual since he is not a licensed physician, physician's assistant, or nurse practitioner. One of the procedures that Dr. Malawi regularly performed was J-plasma, skin tightening. In April 2021, I observed Malawi intentionally extubate a patient. And I'm covering this because this is one of the specific claims of defamation. Specifically, I recall that Dr. Malawi has increasing frustration during an operation with a patient that he did not appear to like. Specifically, during an abdominoplasty closure portion of the procedure, the bed was flexed and the patient's shoulders were shifted over. I observed Malawi aggressively push the patient back to the center of the table, at which time I observed him reach into the patient's mouth and rip out her endotracheal tube and throw it across the room. I assisted the anesthesiologist placed a laryngeal mask airway, LMA, after Malawi extubated the patient. I was extremely disturbed by the behavior and yelled an expletive at him. At any other institution, this would be grounds for immediate termination. I was worried for the patient's health and safety. Given Malawi's action, I raised my concerns with the operating room staff and Malawi's office manager/wife. Attached is a text message on April 29th, 2021 I sent regarding the conduct. This was the last day I worked in the operating room with him because of what I observed. On April 29th, I received a text from the wife stating, "God is watching, remember that." Attached as Exhibit B is a true and correct copy of this text message. I interpreted this as a threat to keep me from speaking about what I witnessed. And he included a text message saying, "Listen, your husband is off his rocker. I think he's lost his mind. He intentionally extubated our patient this morning for no valid reason. His actions show a complete and total disregard for patient safety. I'm willing to overlook some things, counts, timeouts, etc., for the greater good, but this is where I draw the line. He needs some help. If this had occurred in any other institution, he would have been immediately removed from the surgical environment. I think you need to postpone his cases for a few days, let him chill out, and do a little self-reflection. I am a nurse, and it is my primary responsibility by licensure to ensure the patients make it through this experience safely. I'm shocked and saddened by the behavior I witnessed this morning. At least he said something. You know, props for speaking up and saying something. This is the return of the text of them trying to talk. So how was your day? Good morning. Can we chat? That works. Is that still okay? Yes. Perfect. Talk soon. God is watching. Remember that. So this gets into additional patient experiences. And who is this? No, this is another employee. I was employed as an independent contractor, hired to provide massages to patients. And this is the person who does the lymphatic drainage. While patients were fully nude undergoing massages, Malavi would bring in other patients being seen for consultation and show off the patients I was performing massage on. He did not ask the fully nude patient for permission to bring in another patient to observe their body. There were also instances where Malavi would bring in other unknown third parties to view patients that had recently undergone surgery. Malavi did not ask the fully nude patient for permission to bring in another individual to observe their body. There were multiple patients that contracted MRSA while under his care. He marketed Vaser liposuction as being less painful and a speedier recovery than regular liposuction. Dr. Malavi would tell people that they would be able to return to work within a week after surgery. I knew this was untrue and confronted Malavi about his misrepresentation as to recovery time. He responded, "This is the only way I can sell it." I also brought my concerns regarding these types of misrepresentations to Claudia. Claudia said, "Less information, the better. Don't tell them so much." After patients underwent surgery, he rarely followed them postoperatively. A majority of the postoperative care was performed by myself, the lymphatic massage person, and James Gardner. Gardner would write prescriptions for patients. This is not a doctor. Drain seromas, remove sutures, place sutures, and address patient concerns. I declare under penalty of perjury. I don't want to scroll through the picture. Again, I will link this. There is another one. These are the patient experiences. 1, 2, 3, 4, 5, 6, 7. I'm just counting them. 7 additional declarations of patients. So I think that when all taken in total, I will let you decide what you think. But I think this is going to be a long litigation. I think most, when threatened with litigation, would probably just have stopped. But this is interesting when you look at someone being able to use their platform to speak I don't think anyone without a platform would have garnered this number of declarations, because how would you find people to come forward? And we saw that partly in the Toddy Westbrook lawsuit, the first defamation lawsuit in Washington, where you had the case being discussed on social media, on independent media, and on Twitter, and people came forward and gave declarations because of that discussion. So is that good or bad? I think it's a good thing when things are brought to light. Yes, you can't use a platform to harass someone, but is this harassment if what they are sharing is true? So with all of that, these are allegations on both sides. I will be very interested to see what happens with the civil harassment restraining order. If you want to follow along from Chalene's side of this, you can follow along on her podcast. She shares it there. She has publicly linked these. I will publicly link these. Somebody is saying, would this not be a whistleblower situation? I'm going to take a little water. Let me swoop and do a few questions and answer that. Oh, I was wrapping my thoughts on this. Um, and I think we're going to see this continue to be a blend of, where is free speech? What is true? Can lawsuits be used to silence people? Are lawsuits used to silence people? What about using arbitration clauses, et cetera, et cetera? So with all of this, I'm going to be following this. I know some of you are like, okay, well, plastic surgery, it is, it isn't. But at the end of the day, what this case is really about is not plastic surgery. This case is about talking about an experience on a platform and whether or not that's defamatory and whether or not using lawsuits to silence people because they are speaking what they say is their truth, is that defamatory? Is that protected First Amendment speech? And we're seeing that in the slap motion in Los Angeles County with Ethan Klein. And we're going to see that in this slap motion too. It'll be very, very interesting to see what the court decides on the civil harassment restraining order, because the burden has now shifted to the doctor to prove that they are being harassed. And again, this litigation is going to bring can you imagine all of these declarations going before a jury? Yep. So I swooped. I'm going to get to questions. Would this not be a whistleblower situation? The whistleblower statutes protect employees from being retaliated against for saying something. Chalene was a patient, not an employee, but could employees have whistleblower protection? We will see. I think that all of the declarations I have seen in this are from former employees. So we will see what happens. But when we go, when we look at them side by side, you can really see the way that complaints are written versus the way that responses are written. And because it's an anti-slap, they have brought a lot of declarations. And we will cover the response too. We're going to cover both sides of this. But again, will this case come down to splitting hairs on, did Chalene say a patient died on the table when really a patient died at the hospital later, and that the medical board is investigating? So those are allegations that were made, not things that have been proven to happen. But if there's $1 million settlement in a wrongful death suit, then isn't it proven to have happened? Because there's $1 million settlement in a wrongful death suit. And will that kind of splitting hairs be persuasive to a jury? No. Is that kind of splitting hairs enough where a lawyer can say, I filed the lawsuit, this is based on what my client told me, I think there's ground for lawsuits? Yeah. So you guys get to make up your own mind on this. But again, no harassing of anybody, no death threats of anybody. And I am going to do just a few questions because oh my God, 3 hours and 45 minutes, like 2 questions. The mods are like, we are exhausted. No wonder my voice is exhausted. My husband's going to be like, how are you still streaming? Don't you have other things to do? And yes, it's the holidays. I didn't think this would take this long because ADHD time blindness, and I forget how long things take. We should have just done one topic. The live stream that should have been 2 live streams, but it couldn't be. So, Maria asked, why would you pay $1 million if you did nothing wrong, General Wonderman? And that was what the declaration, in this case, the declaration from the lawyer that practices a medical malpractice, opined in their opinion. They said in their opinion, that is what it is. So that's what it is. I am going to go drink something warm. We're like at 3 hours and 45 minutes. It's wild. So we have definitely got to get going. You guys, don't forget to like and subscribe to the channel. I appreciate all of you for being here. We've just set a number at 200K because it'd be fun to hit by the end of the year. Because then we will have been a year going from last October being at 5,000 to the end of this year being at 100 or 200,000. We're almost to 190,000. So go ahead and hit the like, hit the subscribe. I've got a great episode of the Emily Show for you tomorrow. Thank you for being here. Huge thank you to the mods. Thank you. We appreciate you. So I will see you guys we just have to wrap. It's been so long. My voice is so tired. Thank you for being here. I appreciate you. We've got to do the things. We've got to go. Okay, bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.